prior to that hearing, the state had obtained an immunity agreement with the co-defendant in this case on it. Also, in September, in August of that same year, this court had set an evidentiary hearing for October 4th. So that the matter pending where the defense had objected to the immunity issue was going to be addressed in October. Despite that, and without permission of the court, or coming to the court to request the ability to grant both use and transactional immunity to the co-defendant, did so here in front of the court on October 4th, directly made allegations against myself, did not disclose it to the court, but even more so is that made this agreement with the co-defendant, and I believe that did not have the authority to enter an agreement, did not disclose if allowed to testify. And what my suggestion was, the court questioned the co-defendant's counsel in chambers without counsel present, and if allowed to testify, would testify that the state never disclosed to co-defendant's counsel that there was a pending motion before the court to prevent immunity from being granted, and so thereby giving them notice, or not even the authority to enter into the agreement. And so if the questions were asked of co-defense whether or not I ever pressured them, intimidated them, or in any way interfered with the co-defendant testifying, they would say I did not. Further, they would say that had they known that the state was going to be arguing and the court would be deciding whether or not immunity would be granted to the co-defendant, they would have waited for that court's decision prior to entering an agreement. In addition to that, the also in an effort to potentially allow and further evidence that will be shown here today will be the parole hearing, in the state failed to live up to the terms of the parole conditions of the agreement granting immunity by not honoring the conditions set forth in paragraph 13 of the immunity agreement, where they said they would endorse and endorse the release of the co-defendant, and so thereby violating the terms of the parole agreement, thereby should the court decide to, could release the co-defendant from the parole the immunity agreement, and thereby allow Mr. Haas to testify if the court so chose to on it. The very fact that this individual had the opportunity, the state had the opportunity at that hearing to disclose this to the court, knowing that the matter was fully briefed, but then said nothing. And now we're before the court on this very issue. We are now in a situation that literally my client and I are in a situation where every single situation we're at is, we can't count on any information not being at least actually or constructively being known to the state by not being illegally obtained through deception, where the court should have known or should have not been done by the sanctity of attorney-client privilege, or at least been done with knowledge of the court on it. Now the co-defendant information was obtained simply because they said they thought our objection was not worthy, even though this court on October 4th stated that it was very worthy and that we had made a significant argument making this decision enough to where this court was going to consider it, and still hasn't ruled on that matter. And so I believe Mr. Haas's testimony is very important. I believe this court could simply interview him without counsel present to answer those questions. Neither side needs to be present for that to obtain it. It absolutely should protect the co-defendant's privilege on it. I have no objection to you talking to Mr. Haas to obtain the information you need. I have nothing to hide on it. I can't imagine that the state would either. Thank you.
Your Honor, just briefly, 2 seconds about that. First of all, the state wants to be on the record as well, that the state believes that nearly everything that Mr. Jasper said right there is false. And secondarily, the state and the immunity agreement worked almost solely with Haley Priscilla. And they have agreed to let her go. We had very little contact with Mike Haas in this case about the immunity. The state was significantly at odds throughout Mr. Bergdorf's trial with Mr. Haas. We had a more cooperative relationship with Haley, and that's who we always dealt with in dealing with the immunity agreement. Secondarily, the state has lived up to every bit of that agreement, Your Honor. And again, I don't want to answer and respond to every single allegation there, but the state, for the record, disagrees with nearly all the assertions Mr. Jasper made.
Okay, thanks, Mr. Kowalski. So I'm going to be doing a lot of redirecting, I think, for the next 2 days. There are 2 very specific questions that I need evidence on in order to be able to make a decision on the 2 questions that are presented. 1, do we have an issue with the timing with respect to when the immunity letter was provided to the defense, and has there been prejudice? And 2, the issue of the monitoring phone calls, jail mail, and now in the reply brief there's reference to recording of an interview or of a meeting between counsel at the jail in Klondike. So that's what we're going to focus on. And if we stray, because I know there are about 1,000 issues in this case that everybody wants a moment to talk about, if we stray, I'm going to redirect you. So please don't take offense by it. I know that there's a lot of emotion. I had a judge I practiced in front of who would call it heat. There's a lot of it in this case, but I just need the information. And so my goal is just to get everybody on the same track to get me the information I need to make the decision I need to make. So I'm gonna let you put on your cases, but I am gonna redirect. We have 2 days, and that's it. And then I'm in law and motion all day Wednesday. So I don't have any more time to give you guys, unfortunately, on this. Okay, that's 3 of the issues. I ruled on the Haas issue. Mr. Jasper and Mr. Kaczynski have both made a record. The next issue I want to talk about is Stacey Lear. My understanding from the reply that I received, or response, last night, is that Ms. Lear was actually the one who went to the facility and did the analysis at the facility that I had previously ordered. Is it, and I apologize, is Stacey a man or a woman?
The woman, Your Honor. Okay, and that's correct, she was.
Okay, so the defense has endorsed Ms. Lear then as an expert. My understanding is a member of the state was present during her work, is that correct?
That's correct, Your Honor, yes.
Okay, so what's the problem, state?
Thank you, Your Honor, if I may. Your Honor, the state's issue is that Ms. Lear's materials, the data, a significant amount of the data that she apparently bases the opinions she'll be giving was never provided to the state until 5 o'clock last night. That includes a significant volume of discovery that was obtained in response to the subpoena that was sent to IC Solutions, which Your Honor may recall from, I think, January of last year. The state received over 100 pages of Excel spreadsheet data from, we believe, that source last night at 5 p.m. Additionally, Your Honor, when the state requested that the defense comply with their discovery obligations as far as expert opinion, reports, statements, results of testing, analysis, etc., as required under 4615-323 sub 6. That was refused, and we ultimately received a copy of, I believe it was a 31-page expert witness report last night at 5 p.m. So, Your Honor, the state is in a position where we have to come before the court today with a significant volume of data that was just dropped on us last night, and effectively unable to efficiently move through this process in the way that we would normally be prepared before Your Honor. So the state believes that that was a discovery violation. We understand that the process takes some time, but we think it is wholly inappropriate that it's dumped on us at 5 p.m. Sunday night before the Monday morning hearing.
When was the site visit?
Your Honor, I believe it was back in January.
Okay, for the defense, who would like to respond?
I would, Your Honor.
Okay, Mr. Jasper, I don't like, everyone likes quoting me in the briefing. And I think I was very clear at our last hearing that we're not gonna play ambush, we're not gonna play surprise.
No, that's not.
I'm not done, don't interrupt me. 31-page report, 5 o'clock, before a 9 a.m. hearing the next day. That feels ambushy,
I can explain here.
please.
Your Honor, that subpoena's been sitting out there forever on it. We just received the information last week, and it has been provided to them prior to that. We sent that information just last week by email to them. Stacy worked very hard to incorporate that into it. And if you wish, we can get her in here to testify on it, how hard she did to incorporate that. With regards to the state and allowing us to visit the site there, Your Honor allowed us to go visit that. We requested a telephonic conference with Your Honor to the live, because at that, the state was there to observe on it. However, the state had an individual at the computer where we were not able to go into and do the inspection as we had hoped to. However, the IC Solutions information and the report is their information. They have the same amount of time to have an expert look at it to this entire time to comprise their own report. They've elected to sit on their hands for this entire time as well, to have an expert here to speak on their behalf. They'd have an investigator to do their own investigation into these violations on it. We have done nothing but take the information when we got it to have an expert look at it. So for them to say they're criticizing us for having an expert, but we can produce when the information was produced. And when given that we had to pay an extraordinary amount of money to have our expert look at it. Neither one of the counsel here is capable of interpreting it on it. They likewise have the same ability. They have complete access. And since the time from the very beginning, as we have motions pending to interview all of these people currently pending with the court, you've been denied access to interview any of the detention staff. The first time, and why we're asking our experts to be allowed to listen to the testimony here today, is this is the first time we've even been able to talk to a detention staff on it. If normally, had they not done an investigation into themselves and a third party investigated it, we would have a chance to talk to a normal investigation. But here, we've been denied even the access to talk to these witnesses. And that's why we're asking that Stacy Lear be allowed to listen here today to these witnesses for the very first time, because they have stonewalled any access to witnesses for us. Even though these motions have been pending for this time on, it all stopped cooperation. So for them to say we are playing games, Your Honor, we can show that is not the case.
It's the late disclosure that I don't like.
I understand, we couldn't help it. There was no way we could stop it. We can show you when we received the information, and we paid an extraordinary amount of money to have even a report on it. We certainly didn't want to delay this hearing because we wanted to get before you to show you what has happened here. None of this action has been caused by my client. It's all the bad acts of the state. We have not done one thing to cause these violations.
Well, I think that we're gonna have some facts, and we're gonna have some discussion, and we're gonna talk about procedures, and we're gonna talk about notification by defense counsel of numbers that will be called. And we're gonna talk about how a defense attorney should handle themselves in attorney-client calls. You know, every defense attorney has a different procedure, but I sure as heck always disclosed. First thing out of my mouth on a call was, I am so-and-so's attorney, and this call is privileged.
And you don't think,
We're gonna have that evidence. That's the thing, is I don't know the evidence, and I'm excited to hear the evidence, but that's what I wanna hear. So here's the deal. I'm gonna allow Ms. Lear to testify. I don't like this at all. I know that I'm leaving the state very flat-footed, but at the end of the day, the issue on Brady is, I need the evidence, and I need it in the next 2 days. So, I'm not happy at all. I don't want defense to think that this is some show of weakness and that this kind of nonsense is gonna be allowed should this matter proceed to trial. But I need this evidence. And I have these 2 days to hear it. Let's talk about Randy Hood.
or it's a fundamental effect on the system that would impair the ability of the indigent in the future. It is something that, in her mind, the efforts that were, after hearing the testimony, is going to say that her opinion is there's little else that she could imagine being done in her, based on her practices and efforts in hearing the testimony, what she hears from our witnesses that are called.
I don't see the relevance. I just don't. Again, the factual analysis, the specific legal question, the legal guidance that has been given by the Montana Supreme Court, as well as by other jurisdictions, including the circuit law that's been referenced. This is a factually specific question. And again, with all due respect to Ms. Hood, what she did during her career is what she did. That does not translate. If, honestly, what her testimony sounds more like it's appropriate for is a 1983 action, not the action that we see ourselves here presented with today, and whether or not that conduct was egregious. That doesn't factor in. The question of whether or not this is structural error, and such structural error that would require dismissal of the case, is a fact-specific question and analysis that is going to be based on the factual statements of folks actually involved in this question. I don't see how the testimony of Ms. Hood is relevant to that question.
And it may not be until we know what is said by the officers on it. All I'm saying is at this point in time, we don't necessarily know for certain what her opinions are. Again, this is our first opportunity to hear from the officers and the witnesses. This is our first chance, Ron, on it. She has the training experience. She is an expert in her field. She is the foremost expert in the state of Montana, in my belief, on as a public defender and an individual that is beyond reproach when it comes to working in detention facilities as a criminal offense attorney. She's been to more detention centers probably than any other person I can think of. She's worked not only as an attorney, but as a supervisor, so she is ultimately familiar with not only the requirements of detention centers, but also has a unique ability not only with management, but also as the attorney, and as Your Honor stated herself, as a defense attorney. She has the experience to be an expert and have not heard any of the testimony. Her opinion may not well be relevant, but I don't know at this point. It certainly could be on it, and if it is relevant, we won't offer it.
So here's my ruling. At this time, I don't see it as relevant. However, I will allow Ms. Hood to listen to the proceedings via Zoom or in person, I'm not sure. Also, Ms. Lear may listen as an expert.
She's here.
Okay, so she may enter the courtroom even though she's a witness. I assume we're excluding witnesses.
Yes, Your Honor, we would prefer if the court's amenable to have our case agent Tucker present in the courtroom throughout the proceedings.
Okay, and I don't have any issue with that, as typically the state has permitted one factual witness to sit on behalf of the state. So I don't have a problem with that. Ms. Lear may enter the courtroom and observe. Ms. Hood may watch via Zoom. My J.A. Maris is monitoring that, and she can allow Ms. Hood access. But at this time, I don't find Ms. Hood's testimony to be relevant. I will allow the defense to make an offer of proof at the point in time when they would otherwise offer her testimony if they wish. So, final witness that we need to discuss is Justice Nelson. Again, from my perspective, and all due respect to Justice Nelson, I think the law that we all practice is shaped by his opinions that he issued while he was a member of the court. But I am, whether people like it or not, I'm the one who's going to decide how the law applies in this case. And I appreciate, again, Justice Nelson's affidavit, his perspective, but it's my job. And so I do not see how Justice Nelson's testimony would be relevant, again, to the ultimate question, which is my responsibility. Defense?
Thank you, Your Honor. So, can you believe Justice Nelson fits into the same bucket as Randy Hood? His background that's relevant here is not his background as a judge. That's not our intention of calling him. Instead, the intention of calling him, again, depending on what he hears from witnesses, would be based on his background and perspective as a former prosecuting attorney. And as the court has made clear correctly, the processes, the procedures, the norms, standards, customs, practices of communications between a defendant and his counsel are important, and how the government must respect those through those policies, practices, and procedures is likewise important. And that's where he would come in and address it. It has absolutely nothing to do with telling the court how to rule, offering legal opinions. We made it clear in his affidavit, and we would emphasize again that that is not our intention and not what we would elicit. Instead, what we would ask him are questions based on his perspective as a former county attorney working in rural areas as to what jails know, what they should know, what the norms are, what the customs are, what the practices are. The court will be presented with evidence during this hearing about the handbook. There's two versions of a handbook that relates to the Dawson County Correctional Facility that's relevant here, but that's it, Judge. It's a very limited document, and the revisions make slight changes. So there won't be a lot of information on paper in terms of what the rules are and what the process is, what the procedures are. And what Justice Nelson will do is to help add some color to that, add some perspective to that factually, and also to offer opinions that he may have on those factual type issues, and no way to tell the court how to rule.
So I'm going to issue the same ruling then as I did with Ms. Lear, or Ms. Hood, with respect to Justice Nelson, and that is, he's already in the waiting room, presumably, will allow Justice Nelson to observe the testimony that's going to be offered. At this time, I do not find it to be relevant to the question that I have to answer, but I will allow the defense to make an offer of proof at the point in time that you otherwise would call it, and then we can rediscuss the issue.
Very well, thank you, Your Honor.
Any other witness issues?
You want to?
Let's wait till they see what the state has to say first.
Your Honor, I think as far as the hypothetical scenario that we're currently looking at, we would not have any objection to Your Honor reviewing that as well. We may have some more thoughts about the real deal if you're inclined to go into that.
Okay, thank you. I see it, please, Mr. Jasper. And what I'd like to do, because I want this to be as transparent as possible, because I would like to, do you have other demonstratives that you intend to offer?
Yes. Don't think there's, don't you have?
There's just a couple, Your Honor, not too many, and we've agreed with the state on almost all exhibits. Good portion.
Are those marked by letters?
We'll mark them however you'd like them marked.
Okay, perfect. Okay, so they've not been pre-marked.
No.
Correct.
Okay, perfect. So then we're gonna mark this as A for the defense, just so that there's a clear record of what has been handed out. So this is the hypothetical redacted attorney-client phone call that has been provided to the state and to the court. We're gonna mark it as A. All right, I'm fine with proceeding in that fashion, Mr. Jasper, for purposes of the calls. Certainly, once you've been able to provide the actual examples to the state, if they have an objection, go from there.
Okay.
But I do like the idea because it does answer at least that first question where I'm not as interested, I'm gonna be honest, in the fact that there was substantive, I actually am a little uncomfortable with the fact that in the hypothetical, I see words like investigation, subpoena, strategy, that gets a little close to the line for me. For my purposes, the affirmative actions defense counsel took to notify the facility that it was in fact an attorney-client call is what matters to me. So I would be more inclined to look at that exhibit if I didn't see the other kind of more juicy words that make me uncomfortable and get closer to the line of maybe attorney-client, if that makes sense.
And so.
Because I don't care. Here's the deal. The law is clear. If an attorney-client call is listened to, that is the end of the inquiry for the purposes of the court. It doesn't matter, like I said, if you talked about the weather or you talked about strategy. It's the fact that an attorney-client phone call was listened to is the first step of that inquiry.
So Your Honor, I mean, if we call our office, you pick up the phone, they're gonna say, Reed Bell and Jasper attorneys.
Well, I know who you
I
are,
know, but I mean, just,
but you're way on the other side of the state.
no, but I'm saying.
I'm way on this side of the state in eastern Montana.
I know, but when like, if you call my firm and my receptionist picks up the phone, it's going to be answered as a law firm. But the only ones that are.
How about your cell phone?
That's what we're talking about. That's the one, the important one, so.
Okay, Ms. Pat.
Thank you, Your Honor. If we may, before we get into the substantive calls or any exhibits related thereto, I respect that the defense's represented that they have the defendant and discuss this with him. Since he's here today, I'm wondering if we can put that on the record just so there's a clear record that he's here and that was discussed with him and he's okay with it for this defense.
Absolutely.
Thank you.
And for the record, when I asked Mr. Jasper if he had spoken with his client, Mr. Brown is sitting next to him, he did not affirmatively.
Yeah.
I don't think Mr. Brown expected me to talk to him today. Don't be nervous. Mr. Brown, this is an important issue.
Yes, ma'am.
One of the most important fundamental rights that a defendant has is the right to absolute protection of their conversations with their attorneys. What your attorneys are indicating is that you have been talked to about this issue. They've discussed with you a limited waiver of that privilege to simply inform the court and the state of what really introductory language was used on your phone calls. Have you had enough time to speak with your attorneys and members of their staffs about that issue?
Yeah, I fully understand all of it.
Okay. And do you have any objection to a limited waiver of that
Zero.
privilege? Okay. Do you need any more time to speak with counsel about this issue?
No, ma'am.
Okay, thank you, Mr. Brown. Sufficient for the state?
Yes, Your Honor, thank you.
I know that the parties are here. I know that the court has spent a lot of time on this issue. But I'd like the court to consider the state's motion by Ms. Patty and I. And the motion is this, that this hearing should be summarily dismissed and this court should deny relief for the defendant. Because of this. This issue was first raised back in February of 2020 about attorney-client privilege. We are now 2 years later, and the defendant has failed to establish what the court had mentioned a moment ago, that there's been any information shared to anybody. We can listen to a variety of witnesses. We can listen to detention officers. We can listen to Randy Hood. We can listen to IC Solutions. But the defense, within the four corners of the brief, even within the four corners of the brief, have never established after 2 years that any information from these Dawson County detention centers went to the Prairie County Sheriff's Office or went to the investigator. They have failed in that promise. Just like the Brady stuff, if you fail to establish prejudice in your pleadings, you shouldn't even be entitled to a hearing. In the present case, this matter was investigated without objection from Lance Jasper to the court. Mr. Tucker interviewed a number of witnesses, recorded those interviews. All those detention officers have unequivocally said, and this is the discovery in this case, that they've never shared it with anybody. There is not one single fact that the defendant has alleged after over 2 years that shows that any information has been shared. We can listen to all sorts of how long a call was, what the percentage of the call was, what detention officer listened to it. But without establishing that, putting it forth in a brief, which they failed to do, the court has set this hearing a long time out. Even at the eve of the hearing, there's been no information that they've been provided, that the information has been disseminated to the investigator. Now, Mr. Jasper is going to come up here in a moment and talk about how he has not had any contact with the detention officers. The state has thwarted their contact. The court at the last hearing, and this issue was raised, what type of contact he was going to have with detention officers. He could have moved the court afterwards to subpoena them, to ask these questions, but those people have been interviewed, and they have unequivocally stated that they've never shared it with anybody. The people who, the one individual that opened the mail, unequivocally said, not only did he not read it, but they haven't shared it with anybody. Right now, the court is anticipating spending 2 days of the court's resources to hear that there's been people that were unrelated to the investigation, detention officers, that listened to these calls, and that they've never shared it. At the end of the day, and right now, the state believes that there should be a specific offer of proof right now, today. And if the defendant cannot concisely with definitiveness state how this information prejudiced him, how it entered into the investigation, this should be summarily dismissed. If he cannot articulate that now, not with overall things or this or that, but state to this court today who listened to it, I think it should be dismissed. Now, what's going through Mr. Jasper's mind right now is sheriff. The sheriff listened to it. And the sheriff has said he doesn't remember anything, he shut it off, and that he did not provide that to Brad Tucker. Now, if we want to have a limited inquiry that would take about a half hour of what Sheriff Lewis listened to, what knowledge he had, and what was turned over to the investigators, we could do that. We wouldn't have to take 2 days. But that is the only issue of somebody from Prairie County or DCI having any knowledge of this. All the detention staff, everybody there says they've never passed it on, they barely even know what was said. So I think an offer of proof should be made with specificity before we waste the court's time and before we go forward, Your Honor. Thank you.
That information, and the purpose of this hearing is for the court to understand the scope of that, the breadth of that, and get a lot more information about the facts and circumstances of that violation, so it's in a position to assess prejudice. So we respectfully and strongly disagree with the motion.
Anything further, Mr. Kuzinski?
Again, given an opportunity to be specific about, what his offer of proof is going to be, that this investigation was tainted by attorney-client privilege. The defense has failed to do so. We have discovery rules. We have 4615, 322, 323, and those are discovery rules. This can't be a discovery procedure. They wrote a brief saying there's a violation, and they need to come forward today at an evidentiary hearing and establish that. Not a fishing expedition. Maybe they'll find something. It's possible. Maybe if Randy Hood listens to something, it'll be relevant at the end of the day, and we should bring Randy Hood forward. The procedure is you write a brief, you have factual allegations in the brief, and you come to court and you establish those allegations, not other things outside the brief. Right now, they've not established in the brief what specific information went to the investigators. And even when asked to do so right now, he just says the court should consider all this and determine at the end whether there's any prejudice. I think the state is requesting that the court demand an offer of proof of what information was transferred to the investigators in this case. And if they can't do that, the state would ask that the court deny relief to the defendant and deny the motion to dismiss.
I'm going to deny the state's motion at this time. I set forth that this is going to be, we're going to focus on some narrow issues. The defendant has made some allegations that affect his most fundamental constitutional rights. We've got to do an inquiry. Defense has not had the opportunity, Mr. Kaczynski is right, they could have asked for my help, to interview detention staff themselves. So we're going to do it over the next 2 days. We don't have to use the full 2 days, certainly. No one's ever mad when things end early. But we're going to get them under oath. We're going to allow the defense staff.
Where do you live?
Glendive, Montana,
And where do you work, sir?
at the Dawson County Correctional Facility.
How long have you worked there?
So 7 years total. I quit back in September, but I came back roughly 2 months ago
Why'd you quit?
to spend time with my son.
Can you tell the court a little bit about your background before you began working at Dawson County Correctional Facility, please?
As in anything?
Any work experience just generally from the time of high school graduation until you began working at Dawson County Correctional Facility?
Sure. So when I finished up high school, I briefly had a job working at a resort and casino where I kind of helped out every department there. So I was a houseman, I helped maintenance, I helped security, I helped the housekeepers. And then I bought a car and moved to Eastern Montana. And the first job I got in Eastern Montana when I was still 18 would have been, I think that would have been McDonald's. And I moved up through management, ended up becoming the assistant general manager. And then ended up feeling kind of burnt out there. Ended up quitting. I took a month off. And then after a month, I ended up working at the facility.
And what year would that have been, sir, when you first began working?
2000, or at the facility,
Yes, sir.
2018. It was, I believe it was June 18th, 2018.
And so at this point, you've had 6 or 7 years of experience working there?
At this point, I'm 7 years roughly.
And so exhibit 3.
Yes, thank you.
Is that a document you're familiar with, sir?
Yes.
And can you tell the court just a little bit about the process through which you were trained as a corrections or detention officer at Dawson County Correctional Facility? Just give us a sketch of how that went.
As far as all training in general,
Yeah, and we're most focused here on calls and legal mail in particular. So if you could sort of focus on that in particular rather than all the general training, please.
yes. So, I mean, I'll make the general statement first that when you start, you're on training for roughly, I believe, 3 to 4 weeks. I'd say that's about the average. Is your first month really is just training, and they put you with different officers on different shifts to try to get a feel for just the way everyone does things. Regarding mail, we have a male officer, so that's specifically her duties as far as everything ends up going through her. So for me, not being a male officer, I was just taught by watching other officers do it while I was on training. So they would go over the proper procedure, just face to face. showing by example rather than just reading the policies. So we do read all the policies, but they show us right from wrong face to face.
Understand, so there's an on-the-job training component.
There is.
In this document, if you look at page 1, you'll see that it's called Dawson County Correctional Facility County Offender Orientation Handbook, revised January of 2023. I presume there was a version of this in place when you first began working there?
There would have been some version of County Offender Orientation Handbook, yes.
And you mentioned the male officer spelled M-A-I-L, correct?
That is correct.
Okay, and if we turn to page 2 of this exhibit, which I believe is exhibit 1, Your Honor, would you like them sequential?
Yes, and generally defense is making letters.
Okay, so
I'm
B.
gonna throw you off, so.
No, not at all.
this would be B.
Thank you, Your Honor. So if you look at page 2 of his exhibit B, at the top there's a personnel list, which is just helpful in terms of orienting us as to the chain of command there. And I see you listed as one of the corporals. Is that right?
Yes, so back in 2023, I was a corporal, and then I got promoted to a sergeant. But when I quit last year in September, I quit when I was a sergeant, and when I got rehired back, now I'm just an officer, so I'm no longer a corporal.
Time to work your way back up the ladder then.
If I so choose, which I may not.
Yes, sir. And then you mentioned the male officer. We see Officer Nichols listed there under male. Is she the male officer?
She is, yes.
Has she been the male officer during the entire time you worked at DCCF?
To the best of my knowledge, yes.
Are you aware of anyone at DCCF who knows more about the male process than Officer Nichols?
I personally don't think so. I think she would know the most.
Is she available as a resource to other officers if they need to speak with her?
Yes.
Have you observed that happening, where an officer may have a question about the male policy and they connect with Officer Nichols and get some guidance?
Yes.
And give the court a feel for how large Dawson County Correctional Facility is. How many employees work there, including the detention officers?
It differs year to year. Anywhere from, this is just a guess, but probably between 20 and 35 officers. And then there's other support staff, so you could add in another maybe 15 employees, but these are just rough guesses. So maybe all staff, maybe roughly 45 people.
And they're working 24-hour shifts, different people cover different shifts.
There's different people, different shifts, 24/7.
And can you give the court a flavor for how many inmates are typically at the facility?
So at full capacity, well, our facility is both a jail and a state prison. So on the state prison side, upwards of 144 people. And on the county jail side, depending on whether we're empty or not, anywhere between, roughly 20 to 40 people.
And were you a detention officer at the time that Sterling Brown was present at DCCF?
I was a corporal, so as a corporal, one of my duties is to supervise the jail side. So I would have been on the jail side most of my shifts rather than the prison side, yes.
And are those physically divided, the jail side and the prison side?
Yes, there's doors separating them so that the offenders do not mix.
And is it fair to say that you have some different policies and procedures that apply to the jail side as compared to the prison side?
Yes, there's a lot of overlap, but they are different.
And I want to talk with you about legal mail. I also want to talk with you briefly about attorney-client telephone calls. So first of all, what were you taught either by the policy book or through on-the-job training about the importance of respecting the attorney-client privilege, whether it's legal mail or an attorney-client phone call? Can you tell the court about that, please?
Yes, so when it comes to legal matters, and I'll start with mail, from the get-go, we're taught that we are not allowed to read legal mail because that's all private. So when it comes to going through legal mail, you're not reading the actual contents of what's in there. You're looking to make sure that there's no contraband in said envelope or paperwork, and also that it's actually going to an attorney, so their legal office or the courts, or anything that shows that it's clearly going to anyone involved with their legal matters and not just some random person. They're treated differently than normal mail, yes.
And you said we are not allowed to read legal mail. Why not?
The contents of legal mail could be talking about stuff that's not known to the public, I would suppose. It's just none of our business. It's not something we do.
And is that something that you learned from the very beginning of your time at DCCF?
Yes.
And have you ever heard any exceptions to that rule?
No.
No situation where someone says, under these circumstances, we can open an attorney letter or listen to an attorney-client phone call?
No, we're not supposed to do that.
If you turn to page 4 of Exhibit B, there's a section called Mail. And I call your attention to the 4th bullet point down.
I'm sorry, is this page 2?
I'm sorry, page 4?
Mr. Hayhurst, I don't think we admitted it. It was stipulated to by the state.
It is, Your Honor.
So the state is stipulated to be admitted.
Yeah, thank you for that reminder, Your Honor. So do you see the 4th bullet point under mail there, sir?
I do.
Okay. And so it says first that all outgoing mail will be addressed and left unsealed. No markings, kisses, X's, O's, etc. will be on the outside of the envelope. And then it gets to the part that I'm interested in. It says legal mail as defined may be sealed after it is inspected by an officer. The officer will sign the piece of mail to indicate to the mail room that the mail was inspected. If an officer has not signed off on the mail, it will be treated as general correspondence. Did I read that correctly?
Yes.
And is that consistent with your understanding of the procedure at DCCF?
Yes.
Has that always been the procedure to your understanding?
Yes.
And then the sub-bullet under there says legal or privileged correspondence definition. Any correspondence to or from the office of a licensed attorney, court official, and then it goes on from there, correct?
Correct.
So has it always been your understanding that a letter from an inmate to a licensed attorney or law office is to be considered legal mail?
Yes.
You talked briefly about the process for inspecting the letter for contraband, making it clear that you don't read the letter. And so is this as simple, sir, as the inmate taking the letter and just flipping the pages away from you to show that there's nothing hidden in the pages?
For the most part, yes. So they would flip through the pages. I could clearly see there's no contraband or anything taped or stuck to either the letters or the envelope. And then I'm also checking to see who it's addressed to on the paperwork and or envelope. So a legal firm 99% of the time. And then envelopes usually also have the inmate's information. So those are the two things I look for. So going to legal firm or the courts, and then that it's actually said inmate sending it out to them.
Right. And so you're not reading the letter, you're not scanning the letter for any words, you are looking instead for contraband.
That's correct. I'm making sure it's legal mail, not reading the contents of it.
Can you exhibit 1A for us? So I've handed you what's been marked as Exhibit C, which is the envelope, and Exhibit D will be the sticky note. Do you have those in front of you?
Yes.
Tell the court what Exhibit C is.
Exhibit C is an envelope that Sterling Brown would have handed me that is legal mail, that I verified was legal mail with my signature at the top.
And is that your signature there?
That is yes.
What's the number that's with that?
205, that was my badge number as a corporal.
Do you recall this instance when Mr. Brown gave you legal mail to inspect?
Yes, it's hazy because it was a long time ago, but I do remember this, yes.
Tell the court what you remember, what happened.
So again, it's vague, but he would have been in our county APOD, and he would have handed me the envelope and showed me and told me, hey, I need to send out this legal mail. He showed me that it was legal mail, flipped through it. He would have put it in the envelope and sealed it in front of me. And once it was sealed in front of me, I would have signed it and dropped it into a mailbox.
Did Mr. Brown comply with that policy and procedure to the best of your knowledge?
To the best of my knowledge, yes.
You mentioned that mail often will have an inmate name or inmate number put on that.
It is supposed to, because we have a log. We always log legal mail. We log when mail is going out of the facility, and most of the time this is Officer Nichols, but all of us have access to log mail that's going out to make sure we just keep track of it, nothing gets lost, or that we have a paper trail of stuff getting sent out. And that's why we need an inmate name and number and such for the sake of that log.
In this instance, you have a letter going out to who you understand to be a law firm, correct?
That is correct.
And Mr. Brown has told you this is legal mail.
Yes.
And so that information is consistent with what you're seeing with your own eyes?
Yes, it is clearly legal mail.
And at the time, it's my understanding that Mr. Brown may have had some sort of a jaw injury. Do you remember anything about that?
Yeah, I remember when he first arrived at the facility, I believe his mouth would have been wired shut for at least a few weeks straight.
And do you recall that he had another inmate assist, or you asked another inmate to assist in licking the envelope? Do you have any memory of that?
I don't have a memory of that, but that wouldn't be unusual.
Okay. And did you direct Mr. Brown to write his name and inmate number on this letter under the circumstances here where you see it's a law firm where it's going to?
I did not.
Why not?
It didn't cross my mind. So despite knowing the general procedure for mail, it's not something I deal with super regularly as far as like the mail officer would do. So I followed the procedure as far as confirming it was legal mail, but it never crossed my mind to tell him to put his name on it. I did not tell him to do that, no.
And do you have any reason to believe that Mr. Brown would not have complied if you had asked him to write his name and inmate number on it?
I have no reason to believe he wouldn't have done it if I asked.
And was he cooperative with you in mailing these letters or getting them ready to be mailed?
Yeah, he was cooperative.
Did you find any contraband or any problems with these letters?
No,
Would you have signed off on them if you had?
no.
Do you recall that there were multiple envelopes that Mr. Brown was mailing out that day?
No, my memory doesn't go back that far.
Do you recall telling Mr. Brown that it was unnecessary for him to put his name on the envelope?
I don't recall that, no.
Did you later learn that this letter had been opened.
That is what I heard, yes.
Take a look at Exhibit D, which is the sticky note. Have you seen that document before?
No,
Do you recognize the signature there?
yes.
Whose is it?
Sergeant Miller, who is no longer employed at the facility.
And is the first name Brashton?
Yes,
Okay. For the record, can you read that note to us, please?
yes. Nichols, we opened these 2 envelopes to see whose they are, but we were unable to I don't know if that says identify.
Maybe we were unable to and didn't.
Oh, we were, sorry. But we were unable to, plus didn't want to open them all. Signed Brashton Miller. Ellerton says they are Brown in County A.
Do you recall having any discussion with Miller about those letters?
I don't recall a discussion with Miller.
Do you have any idea what this is referring to when it says Ellerton says they are Brown in County A?
My memory is too hazy for back then, whether or not I would have talked to Miller.
What you do know, though, is that no one asked you about these letters before they were opened.
I don't believe anyone did because I was on day shift, and my understanding from what I heard is they would have been opened on night shift, and I wouldn't have been at the facility. So I don't recall anyone asking me about the letters because I would have been home for the day. That's the best of my understanding.
If you had been contacted and asked about the letters, what would you have said?
This letter belongs to Sterling Brown, and I confirmed it was legal mail. And then at that point, they could have probably added, or had him add his name plus CF number that was assigned to him at the jail.
In terms of getting a hold of you, you're working day shift. Miller was working night shift.
Yes,
Is there a phone list that allows officers to get a hold of you when you're off duty?
yes,
Has that happened before?
yes,
Did they contact you that night to ask about these letters?
no,
What about email? Do you have email at DCCF?
we have a work email. We don't use personal emails. But yes, we have emails.
And do you sometimes receive questions from other officers?
So for corporals, sergeants, and higher up than that, we have emails where we, on a daily basis when we're working, email each other and verify things. So now as an officer, there's no email correspondence, but back when I was a corporal, there would have been, yes.
And would you have had access to that email when you were off duty?
No,
Do you recall any email at any time from anyone about this letter that was opened?
I don't recall one, but I don't remember.
Would the legal mail process have allowed the night shift to know that this was a letter from the jail side as opposed to the prison side?
In most circumstances, yes, and I could explain that if you want me to.
Please do, thank you.
So on our jail side, each one of the pods has a wooden mailbox with a padlock on it. So anytime county inmates are sending out mail, whether legal or not, it gets put in set mailboxes. And one of the officers on night shift picks up said mail. And it's basically the same process for the other side of the building, but they generally don't mix. So unless someone mixed them, which doesn't happen, it's pretty clear to know that one pile of mail is county side and another pile of mail is state side.
Which means if you had a question about a letter going out, you would just need to go to the jail side or the county side to know where it came from.
So if there was a pile of county mail without a name or a number, you would know it came from county side. You just wouldn't know whose it was.
And one option, of course, is to go ask the inmates, correct?
That would be an option, yes.
And when you're talking about asking the inmates on the county side, that's the approximately 20 people who are typically there?
That's correct.
Do you have any reason to believe that if Mr. Brown had been asked whether these were his letters, that he would not have told the truth and said they're his?
I have no reason to believe he wouldn't have told the truth, no.
Do you have any reason to believe that anyone asked Mr. Brown about those letters before they opened them?
I don't know that anyone did or didn't. I don't know.
Turning back to Exhibit B, which is the handbook for DCCF, on pages 4 and 5, this is the mail section. And I'll tell you, I don't see anything in here that says that the jail can open legal mail. Are you aware of any rule, written or otherwise, or policy that permits that to happen?
Not to my knowledge, no.
If you look at the very last bullet in the mail section on page 5 of Exhibit B, it says undeliverable mail. Do you see that?
Is this page 5?
Yes, sir.
And which bullet point was this?
The very last one, undeliverable mail.
Yes, I see that.
Is that what's written there? Is that your understanding of how undeliverable mail is handled?
I will read it real quick. And what was your question, sir?
Is that consistent with your understanding of how undeliverable mail is handled?
Yes, it's not something I've ever personally dealt with, but I believe I have read this before, yes.
And the gist is, if there's a letter that doesn't meet the standards and is going out or coming in, the inmate's given notice and a chance to speak up. Is that fair?
I believe so, yes.
And if you turn to page 4, third bullet from the bottom there, about midway through, it says undeliverable mail may be destroyed or mailed out at the inmate's expense. You see where that's written about midway through that third bullet from the bottom?
You said this one was page 4 now?
Yes, sir.
I am not seeing it.
The third bullet from the bottom starts with Dawson County Jail. Do you see that bullet?
Yes.
About 3 lines down, it says undeliverable mail may be destroyed or mailed out at inmate's expense.
Yes, I see that.
Is that consistent with your understanding of both the written and unwritten policy at DCCF?
Yes. Again, not something I've ever dealt with, but I don't believe that would be a new policy, no.
And you've never seen a situation where undeliverable mail was opened if it was legal mail?
No, I haven't seen that, no.
So this situation that we have in this case here, where legal mail from an inmate, Sterling Brown, was opened, is that unprecedented in your experience at DCCF?
It's definitely not something that's common. To my knowledge, it's the first time that I've heard it happen like this. If it's happened in the past, which is very possible, I don't have any experience with it. I don't deal with mail that often.
But it's not something you ever heard of either before or since?
Not this is the only specific circumstance that I'm aware of, but again, I don't deal with mail that often.
Do you recall being interviewed about this incident by a DCI agent named Brad Tucker?
Yes,
And he's here in the courtroom with us today?
yes,
Thank you. And I presume you didn't see a copy of his report, did you?
I did not know.
And I'm just going to move through this quickly. We'll cover that in more depth with Mr. Tucker himself. But if he wrote in his report on page 23, Corporal Ellerton stated that he would not have personally opened the letter and would likely have gone to every inmate on the county side to determine the inmate, would that be consistent with what you had told him?
Yes,
How long would it have taken an officer to go to the county side and ask the inmates who were there at the time to find out whose letter it would have been?
going through every single person. Could probably do that in 10 minutes.
Just want to transition briefly to telephone calls. Well, first off, is there anything else about this legal mail issue that you have knowledge of that is germane here so that the court gets the full story?
No, I don't.
If you take a look back at Exhibit B, the handbook, there's a section in here on communications and phone privileges. That's page 6. Do you see that?
Yes,
Second bullet down under phone privileges. All calls made using the inmate phones, with the exception of those with verified attorneys, are subject to recording and monitoring by DCCF staff. Did I read that correctly?
yes,
Is that consistent with your understanding of the policies and procedures at DCCF?
yes,
Is that the written rule and the unwritten rule?
yes.
Are you aware at any time other than with Sterling Brown of attorney-client phone calls being recorded and listened to?
Yes, so over the years, and I mean, this is pretty vague, but we always give the option for the phone calls that aren't recorded, because that's default, that they're not recorded. If an attorney chooses to have a phone call to their discretion of something they deem not important, I believe some attorneys have called on a recorded line before, but not because they were forced to. It would have been their own discretion to choose to do so. It's not something that ever happens commonly, but I believe I've seen it happen over the course of 7 years.
And so if I get what you're saying correctly, you're talking about a non-substantive conversation between an attorney and his client, that the attorney is knowingly saying it's okay to record this.
Yes, most likely not a lot of substance.
Are you aware at any time of Sterling Brown giving authorization for his attorney-client phone calls to be recorded?
I don't know anything about that.
Do you know the process, if any, that existed in the first part of 2023? So I'm talking about January through, let's say, August of 2023, about whether there was any form that existed at DCCF for an attorney to register their name and phone number.
So I don't know said process. My understanding is that there's a form, and I believe that's generally a member of our administration that deals with that. So as a corporal, it's not something I've ever seen or done. I don't know the procedure. I just vaguely know that there's paperwork for the procedure, but it's not anything I have any knowledge on.
And if there's testimony from other officers at DCCF and from Tucker himself, that form came into being in November of 2023, after Sterling Brown had already left DCCF, would you have any reason to disagree with that testimony?
If that's what they testify and they have more knowledge than me, especially someone in administration, I wouldn't argue against that, no.
And just last question on attorney phone calls. Have you ever placed a call to an attorney yourself as a detention officer for any reason?
Calling the number back, well, in what sort of scenario at all?
Just at all?
I mean, yes, so we call attorneys and let them know so-and-so offender is requesting to speak to you. We do that a lot. We leave a voicemail. Or if an attorney calls and we weren't able to get an offender to the phone, we will call them back to make sure the said phone call can happen.
And so in that instance, it's a situation where the detention officer is calling an attorney who they know to be representing one of the inmates.
Correct.
And so if a law firm then has an incoming call from DCCF to their number, it means that some detention officer at the facility was aware that they were representing an inmate.
Yeah, I would assume an officer calling an attorney from the facility in most circumstances would be doing it for an inmate.
Can you think of any situation where it would be otherwise?
If
Let me ask you a different way. Have you ever encountered any other situation yourself?
not that I can think of.
And then last thing is your statement. Mark, this is Exhibit E, and I believe this is a stipulated exhibit, Your Honor.
State.
And I'm not going to go through this with you, sir. I just want to ask a couple questions. You recall when you were interviewed by Agent Tucker that he recorded the conversation?
I do, yes.
And if this is represented to be a transcript of that interview, would you have any reason to disagree with it?
I don't have any reason to.
No further questions at this time, Your Honor. Thank you.
I'd like to go back to when the defendant had legal mail, when you signed off on it. It's my understanding that you are advised that it is legal mail. Is that correct?
Yes,
And your primary job is to look at and place that mail into an envelope and make sure that there's no contraband with that mail, right?
right.
You are not making a determination whether or not he's in compliance with all the policies and procedures of Dawson County Correctional Facility, is that right?
That's right. I follow the general guideline of knowing whether something is or isn't obviously legal mail, and then making sure there's no contraband, and then making sure said mail gets to the mail officer. But at that point, she's the one with the expertise that I don't know all the ins and outs of the policy.
And that's Kay Nichols, correct?
That's correct.
And so Officer Nichols is the one that makes that final determination of whether the mail should be outgoing mail and should be delivered, is that right?
That's right.
And whether it's legal mail, is that right?
That's right.
Your signature on the envelope after the defendant places the correspondence in the envelope does not indicate that you're affirming that he's in compliance with all the policies and procedures of outgoing mail, is that correct?
That's correct.
And the defendant himself, when he is placed in the Dawson County Correctional Facility, he gets a handbook, right?
Yes, so at the time, they either had access to a handbook. We used to have physical copies that looked like this. And then at some point, and I can't recall when, we got tablets. but my understanding is that on those tablets, they had access to the handbook. So whether or not they had the physical copy, they should have had a copy of the handbook in some form.
And that handbook would be made available to the defendant themselves, each defendant at the Dawson County Correctional Facility.
That's my understanding, yes.
And certainly if a defendant's attorney wanted to look at those policy manuals or orientation manuals, they could do so as well, right?
Absolutely.
And the handbook themselves describe the procedure at length about outgoing mail, right?
Yes,
It talks about legal mail, right?
yes,
And you also have a process set up at the Dawson County Correctional Facility where attorneys can speak with defendants, not on the IC solution line, but on a private unrecorded line, right?
yes,
And those calls, those private unrecorded lines, they don't say that the call is being recorded, do they?
no,
But when you use IC solutions, every single call says it's being recorded, right?
yeah, I believe it's one of the first things that it says when you make a call.
And also IC solutions also charges the inmate to use, is that correct?
That's correct.
The time that a defendant wants to talk to the attorney on the unrecorded line, on that private line, there's no charge, right?
That's correct.
You were asked a moment ago about whether this is unprecedented, that somebody ever looked at this mill, right?
Yes,
And it's also been stated at this hearing that it's unprecedented that people listen to the IC Solutions jail talk between the defendant and his attorney.
yes,
So both these things are unprecedented. The way Mr. Brown communicates by legal mail with his attorney, and also the way Mr. Brown's phone calls were listened to with his attorney, right?
yes,
And it could be unprecedented for one or two reasons. Either the detention center made huge horrific mistakes, disregarded his privacy rights with his attorney with mail, and they also made huge mistakes with regards to his attorney-client phone calls, right? That could be a possibility, right?
it's possible.
Yeah, but the unprecedented nature of this can also be because the attorney and the defendant themselves both did not follow proper procedure with the Dawson County Correctional Facility, right?
That's possible as well, yes.
Do you find it coincidental that both these things, the mail of Mr. Brown and his phone call communications, have been determined unprecedented when it's both the same person?
It's kind of out of the ordinary.
Now, I'd like to go back and start with the mail themselves. Now, anybody that reviewed the handbook, whether it be Mr. Brown or the attorney, could clearly see that all outgoing mail must have the inmate's name on it, correct?
Yes,
And it must also have, I believe it's called a CF number, is that right?
yes.
And what is a CF number?
I cannot recall what CF stands for, but CF numbers are issued to any of the offenders on our jail side, whereas any of the inmates on the state side have an AO number. So it's the number that's assigned to them upon their arrival that everyone uses. There's only one number issued to them, and that's their number.
So it's a unique identifier for that inmate, right?
That's correct, yes.
And so the policy clearly states that for outgoing mail, whether it's for your attorney, whether it's for your loved one, that it needs to state these two things, right?
Yes,
And the attorney would have knowledge of this, right?
yes,
And again, this is some of the most important communications that an inmate may have their whole life. The sanctity of attorney-client privilege, right?
yes,
And you would now expect that an inmate's attorney would thwart the policy and send his own client an envelope that's depicted in Defense 1A. You still have that in front of you?
yes, I do.
Could you look at that, please?
Yes,
And Defense 1A is an envelope, appears to be printed by Mr. Jasper's law firm, right?
Yes,
And it also has Mr. Jasper's address on it, right?
yes,
And nowhere on this envelope does the defendant comply with the policies and procedures of Dawson County Correctional Facility, is that right?
that's correct.
There is no name on it, and there's no CF number on it, right?
Correct. Generally, an envelope wouldn't have anything in the top left for inmate information.
And so what the defense counsel just asked you was one way you could determine who had this envelope, whose contents are inside this, and that is to go around to every pod and ask everybody, whose is this, right?
Yes,
That's one way. But you can also open it to see who it is, a little bit of it, right?
you could.
And you could do so without reading it, right?
You could.
And why do you think the policy,
Mr. Kaczynski, is Exhibit C, just so we're clear.
oh, I'm sorry, I said defendant 1A, I'm sorry, so it's Exhibit C?
Correct.
All right, I'm sorry, Your Honor, thank you. Why do you think it's a policy and procedure that the inmate's name is on here?
Well, one of the main reasons is because we log outgoing mail. Just so we have a paper trail of stuff going in and out so that things don't get lost. But that's another thing in case, especially for legal mail, if the facility got mail sent out and then upon delivery, something happened and something went wrong, that it could be returned to the correct person.
And you have 200 inmates at the full facility, 160 and another 20 or 40?
Yeah, generally, when we're not super empty, we have over 150 people, yeah.
It's pretty clear to you, isn't it, that had the simple policy of putting your name on this envelope been complied with by the defendant and his defense counsel, that this wouldn't have been open, is that right?
Yeah, there would be no reason to open it if the inmate name was on it.
We talked about the phone calls earlier. And it's incumbent upon every defense attorney, even before the policy, was to register their name with the facility, right?
I'm sorry, could you repeat that?
The process was defense attorneys would register their name with the Dawson County Correctional Facility, so those calls would be blocked, is that right?
Yeah, that's my understanding.
And so if you didn't follow through with that either, if you didn't comply with what was necessitated at the facility, then somebody may listen to the call inadvertently, right?
Yeah, so again, not my specialty, not being the mail officer, but my understanding is that an offender's attorney is supposed to request to get their number blocked. So the attorney would get a hold of our administration for the administration to block the number. So I guess in a scenario, if an attorney didn't do that, there would be no reason to assume that it wouldn't be recorded had they not made that request.
And you would expect that an attorney that was genuinely interested in protecting his attorney-client rights with his client would make sure that he knew the process at Dawson County Correctional Facility of ensuring that nobody listened to his call, right?
Yes,
And especially because every time he talks to his client on the IC Solutions, he's told this being recorded, right?
yes.
And earlier you were asked if people could ask Ms. Nichols questions, whether other officers could ask Ms. Nichols questions and use her as a resource, right?
Yes,
Any attorney, especially an out-of-area attorney, could call the Dawson County Correctional Facility every time they heard this is being recorded, and they could have found out the procedure and ensured their own client's rights were being protected when they heard it was being recorded every time, right?
yes, I believe she works 5 days a week.
And also, you could save your client some money by just making arrangements to talk on the private line with your client as well, right?
Yes,
And you would expect if an attorney ever believed that their attorney-client rights were being violated through listening to phone calls, and they genuinely wanted to protect their rights, they wouldn't wait 8 months to report it, right?
Absolutely not.
When you saw that envelope being, the correspondence being placed in that envelope, you never read the contents of that, right?
No, never.
And in your dealings with other officers, other detention staff, are you aware of whether anybody has ever read the contents of any of those letters sent by the defendant to his attorney?
No, they drill it in your head day one when you start working as an officer there that you absolutely cannot read the contents of legal mail.
So they drill that in. That's really, really important.
Yeah, no one does that to my knowledge.
And in a situation where you have an envelope that's leaving a secure detention facility with no inmate's name on it, you have no idea who it's from, do you think it's unreasonable to open the letter to see who it's from?
No, it's not what I would do personally, but I can understand why it happened.
Sure. And you can imagine doing so without actually looking at the contents, right?
Yeah.
One moment, Gunner.
Not to read attorney-client mail at DCCF, right?
Yes, we cannot do that.
Can't read it, can't peruse it, nothing like that, right?
Can't read the actual substance of the envelope. So you're not reading the meat of a letter. You're looking to make sure that it's addressed to counsel and that just like if I saw that it was going to Lance P. Jasper, I would know that it's legal mail without reading any of the contents.
Right, so when you look at the exhibit, and for the record, both the exhibit and the sticky note are stipulated here, Your Honor. If you look at that letter, you know just by looking at the outside of that letter, it's legal mail, correct?
Yes, it's legal mail. Someone looking at it wouldn't know who it belongs to, but they would know that it's legal mail, yes.
Right, and your testimony is you wouldn't have opened it because there was a whole bunch of ways that you could have found out who sent it without opening it, right?
I personally wouldn't have opened it.
Right. And there's a whole bunch of options short of opening the letter, including talking to inmates, talking to you, talking to Officer Nichols, who's in charge of mail. Those are just 3, right?
Yes, those are other options.
And you can pick up your telephone and Google the law firm name too and get information about them if you needed to, right?
Yes.
How many inmates were represented by a law firm from Missoula, Montana when Sterling Brown was incarcerated at DCCF?
Oh, I'm not sure. We have people represented from different towns across the state, so I have no clue.
Is it fair to say that Missoula isn't one of the typical law firm areas for DCCF?
I don't know. I've seen Missoula, Billings. I've seen a lot of places. It's very possible that more than one person could be represented by someone from Missoula.
And you were asked about whether this was read or how it was read. You have no information whatsoever on what was read in this letter, correct?
No, my understanding is I wouldn't have been working when it was opened.
And you were asked about the manual, the handbook that covers inmates, right?
Yes.
And so when inmates come into the facility, they're provided typically with these handbooks, that's what you're saying?
Yes, again, whether they have access to a paper copy or on the tablets, I'm not sure at the time, because those tablets were introduced as a new thing. But generally, to my knowledge, everyone has access to it.
And when an inmate receives something from the jail, whether it's a handbook, a policy, or likewise, when something is taken from the inmate when they arrive, like their personal belongings, that's documented, correct?
Yes, it should be.
It should be in the jail file for that inmate, correct?
Yes, if procedure is followed properly, Yes,
And when a handbook is updated, for example, during the time that Mr. Brown was there, the updated version, that's also documented that they're given the new rules, right?
that's my understanding.
Because you can't expect people to follow rules that they're not provided, right?
That's correct, yes.
And what you're telling us is that this inmate name on the envelope, the purpose of that rule is to have a logbook. That's the entire purpose, to your understanding.
To keep track and make sure that mail doesn't get lost and make sure that it either goes to the person it's being sent out to or can properly be returned to the person sending it out.
Right. And we already went through the policy, but despite questions about they wouldn't have had to open these, you know of no rule that says the jail can ever open a law attorney-client letter, correct?
Correct. It's not my specialty, but I don't believe that there's a reason to open it.
You were asked some questions about whether Mr. Brown's lawyers were trying to thwart the policy. Do you have any evidence yourself that any lawyer for Mr. Brown was thwarting the policy?
Not that I know of. I didn't have much contact with the attorneys.
You were asked about the process for blocking attorney phone numbers. Do you have any evidence or reason to believe that that process wasn't followed here by Mr. Brown's attorneys?
So, again, I have zero involvement in that process. I don't even know what the full process is. I just vaguely know that an attorney is supposed to request and fill out paperwork to get a number blocked. But that, as a corporal, I wouldn't deal with that. That would have been, to my understanding, an administration thing.
So do you have any evidence or information about Sterling Brown's attorneys allegedly waiting for 8 months to raise the issue?
I don't have any knowledge one way or the other.
Do you know that after these letters were opened, that Officer Nichols went and talked to Mr. Brown? Are you aware of that?
No, I don't know anything about that.
Also, is there a room, like a video courtroom at the jail where inmates use that room to contact their attorneys?
Yes, we have a contact visitation room, and sometimes we use that specific room for them to contact attorneys.
Is it possible for the detention officers to monitor what happens in that room?
They can monitor it on video from one of the many video cameras in the prison.
And you already said that you personally wouldn't have opened the letter. Let me ask you this. If you were monitoring or listening to a phone call and the person said this is an attorney-client phone call and identified themselves as an attorney, what would you do?
If I were listening to a recorded phone call between an attorney and an inmate,
Yes, sir.
you're just asking what I would do if I heard that?
Yes, sir.
I would personally not listen to the phone call.
And is that consistent with your training as an officer at DCCF, that you shouldn't listen to any attorney-client phone calls?
I mean, yes.
No further questions? Thank you.
The rule that allows for a detention officer to open legal mail. Remember that?
Yes.
And you said no.
Not that I know of.
But you do know that there's rules about legal mail that were clearly not followed by the defendant in this case, right?
Yes.
And not only the defendant, the defensive attorney, when he provides his client with an envelope to mail back to him that clearly doesn't comply with the policy of the detention center, right?
Yes, that's generally where someone would write their inmate information.
We talked earlier about the fact that the defense is talking about that there's been irregularities by the detention center with regard to mail. And obviously you have this idea that there's been allegations against the detention center regarding phone calls, right?
Yes,
When you're thinking about this, that it's both the same entity that's making allegations about two different types of communications, and that we discussed earlier that there's procedures not being followed, do you think it's possible that defense counsel, the defendant, would deliberately create a situation where you guys falter, where you open mail because the envelope doesn't list who the defendant is,
it's possible.
and do not comply with protecting their own clients, client privilege with phone calls, again, so there'd be missteps.
Yeah, it's my understanding that most attorneys do make that request so that phone calls are not recorded.
Thank you, nothing further.
Nichols, K-A-Y-E-N-I-C-H-O-L-S.
Thank you. You may proceed.
Thank you, Your Honor. Officer Nichols, how are you?
Good, how are you doing?
Were your ears burning?
It feels like I'm back in high school speech class.
Can you just give the judge a little bit of background on your work history from high school up until your current employment, please?
Well, from high school, I worked in, at East Mountain, which is a facility for developmentally disabled adults, and I went to work with group homes. I'm sorry. So, first jobs were at a care facility for developmentally disabled adults. And then when that place closed, they moved into group homes, and so I worked there for a while. And I have been at the prison since 2006.
I mean, you say prison, do you mean,
At the Dawson County Correctional Facility.
can we call that DCCF?
Yes.
Can you tell the court about your jobs that you held at DCCF over the years, please?
I've been a floor officer, corporal, a sergeant, transportation officer. Now I work in the mail room and handle the inmate mail and inmate classifications.
How long have you been in charge of inmate mail?
I believe 8 or 9 years.
Can you tell the court what that job involves, please?
So I process all the incoming and outgoing mail. All the outgoing and incoming general correspondence is searched and read. Search for contraband, read to see mostly are they making plans to try to introduce contraband into the prison.
How much training have you had when it comes to attorney-client privilege, jail mail, things like that?
I trained with the previous mail officer for a couple of days. But then we also shared an office, so if I had any questions, I could ask her at any point.
Who was that?
That was Danielle Doctor.
So she was the mail officer before you.
Correct.
How long did she have that position?
I don't know, I think it was a few years.
And did she kind of teach you on the job?
Yes.
And did you also learn from reviewing the manual?
From policy and procedure, yes.
In front of you, there should be a document identified, Exhibit B. It's the County Offender Orientation Handbook. Can you see that in front of you?
Yes.
And first, if you turn to page 2 of that document, it identifies you as the mail officer, correct?
Yes.
And we talked about this last with the previous witness, but this is sort of the chain of command here at the facility that we see summarized here at the top.
Correct.
Is it fair to say that DCCF is a relatively small facility in the world of prisons and jails?
Yes.
Is it fair to say that you have close contact with your fellow officers?
Yes.
Do you have communications with them?
Yes.
By word, by email, things like that?
Yes.
Are you known as the mail guru around there?
Well, I don't know about guru, but yes, I would be the go-to person for any questions with mail.
Is there anyone at the facility who has more training and experience in mail than you do currently?
No.
Have you had officers come to you with questions about mail over the years?
Yes.
And have you answered those questions to the best of your ability?
Yes.
I understand that there's some type of a phone list at DCCF for officers, so if there's a question that they may have of you, but you're not on shift, they can get a hold of you.
Yes, they could.
Has that happened in the past?
Possibly once or twice, but I can't remember the circumstances.
Were you the mail officer when that happened?
Yes.
Does everyone know you're the mail officer there?
Yes.
Inmates and detention officers both?
Yes.
Would you describe for the court how you were trained or what you were trained as a detention officer when it comes to the attorney-client privilege and protecting that privilege with legal mail?
I believe they covered some of that in the academy, but that was 16, 17 years ago, so I couldn't tell you specifically what that was. Mostly it is from the policies, procedures that lay it out on what is privileged and what isn't.
And what's the upshot? I mean, without getting into the specific policy language, what is the rule at DCCF when it comes to respecting attorney-client privileged communications?
We cannot read any privileged communications. We can't even scan it anymore. Policy used to say scan, and now it is just visually inspect for contraband.
You said that we cannot even scan it anymore?
Scan it as in, like, oh, that looks like a legal document kind of a thing. Not read it, not try to find out what is in the document. Policy used to state visually scan. It does not say that anymore.
When did it change that policy?
It's been that way for a long time. Several years.
At the time that Sterling Brown was an inmate at DCCF, the rule was officers cannot read legal mail, nor can they even scan legal mail, correct?
I'm not sure specifically what it said.
Yes,
I believe when it had scan in there, it was staff will visually scan the mail for contraband. It wasn't scanning as in skimming it to try to determine what was in the documents.
And if you take a look at that manual that's in front of you there, the handbook, and turn to page 4, is that the mail procedure?
No. It is stuff regarding the mail, but it is not the actual procedure. This is more of a condensed version of the procedure.
So are you saying there's a more detailed policy or procedure than the document you have in front of you?
Correct.
What is that document?
It is the policy number 3.3.6 offender mail.
What does that policy say about mail?
Well, it's like 12 or 14 pages. Is there anything, were you talking about legal mail specifically?
Yes.
So for it to be legal mail, it needs to meet the definition of legal mail. And at the time that Brown was there, it was to or from a court, attorney, an advocacy group, anyone that was authorized to receive PREA correspondence. So that was the definition of legal. And for us to treat it as legal mail, it needed to meet that definition of legal mail. It needed to have the inmate's name and number on it. It needed to be clearly marked as legal mail or privileged correspondence. And if the inmate wanted to seal the envelope, they would have to do it in front of an officer. The officer would look at it for any obvious contraband, and then give the inmate the okay to seal it. And then the officer would sign off on the back so that I knew when it came to the mailroom that somebody had witnessed it being sealed.
In the exhibit that you have in front of you, the handbook there, that's the document that is available or supposed to be available for inmates, correct?
It is available for them, yes.
And that's the information that the inmate would then have to understand the process, correct?
He had access to the policy as well.
Okay. And if you turn to page 4 of the handbook there in front of you and you look at that 4th bullet down there, you see where it defines legal mail in that bullet?
Yes.
So and I want to make sure this is the process. It says legal mail as defined may be sealed after it is inspected by an officer. The officer will sign the piece of mail to indicate that the mailroom that the mail was inspected. If an officer has not signed off on the mail, it will be treated as general correspondence. Did I read that correctly?
Yes.
And is that the policy that was in place at the time Sterling Brown was an inmate?
Yes.
And then it goes on in the next bullet to define legal and privileged correspondence, correct?
Yes.
And that is, just as you said, any correspondence to or from the office of a licensed attorney, court official, and so on, correct?
Yes.
And that definition was in place at the time that Sterling Brown was at DCCF, correct?
Yes.
You said that at one point in time there was a policy that said they could scan the mail. Am I hearing that right?
What are we talking about scan? Like, we're not talking electronically scan. It's never been that way for legal mail.
No, I appreciate that clarification. And so scan as in,
Visually scan as in you could look at the pages to see if there was any contraband on them.
do you see anything in the exhibit in front of you that talks about the ability of an officer to scan the mail as you just defined it?
No, and I believe that that part was in policy before, it had changed before Brown was there. Like I said, it's been several years since it was listed that way, and I'm imagining this is why we changed it, just to make it clear that there is no reading of it.
And so to be clear then, the language about scanning mail, as in perusing mail, that rule was not in place. That was not allowed when Sterling Brown was an inmate at DCCF in 2023.
Correct, I believe it said just visually check the mail for contraband.
And the purpose of that rule is to ensure that the attorney-client privilege is protected. Is that right?
Correct.
And that's the goal when it
Yes.
comes to this, correct?
We want to do what we can to limit, ideally eliminate any contraband coming into the prison and making plans to arrange that contraband coming in. But correct, we don't want to violate their rights regarding attorney-client privilege.
You mentioned the requirement about having an inmate name and number on mail, correct?
Yes.
Is there anything in the handbook in front of you that says legal mail is not legal mail if the name of the inmate and his number is missing?
No, just on the general correspondence below that.
Right, and so general correspondence, that is not legal mail, correct?
Correct.
Legal mail gets its own specific rules and its own specific protections, correct?
Correct.
And what the rules say is that if you have a piece of mail that's undeliverable for some reason, that undeliverable mail may be destroyed or mailed out at the inmate's expense, correct?
Correct.
And likewise, the very last bullet on page 5, undeliverable mail, talks about providing notice to the inmate so they have an opportunity to challenge that decision or ask questions about the mail, correct?
Provided that the incoming mail was not opened.
And nowhere in these rules that we see in the handbook does it say that a detention officer can open legal mail, correct?
It says that if it does not meet policy definition of legal mail or the requirements of legal mail, then it will be treated as general correspondence.
And then what happens?
Then it gets treated as general correspondence,
Which means what?
that it can be opened.
Have you ever had an instance of legal mail being opened at your detention facility?
Yes.
Involving Mr. Brown or involving others?
There was nothing with Brown other than this one incident. For others, there have been a couple occasions where the courts don't put the inmate's name on it, so I have to open it to find out who it belongs to. There was once when I accidentally opened a piece of legal mail. It was, so per policy, technically it still wasn't legal mail because it was not marked as legal correspondence. The attorney put first name, last name, and attorney in the return address, and it was handwritten. So with that being handwritten, not typed, and not stamped, I did not notice it was legal mail. As soon as I opened it up, obviously legal documents tend to have a very specific format. You can tell what a legal document is, and as soon as I saw that, I closed it back up, explained to the inmate what happened, and kind of changed my procedures to do a double check in there to ensure it wouldn't happen again.
And in that instance, did you read that legal mail?
I did not. No.
Did you even scan it?
Nope.
You were able to tell it was legal mail just with a glance?
Yes.
And then you closed it up and took it from there?
Yes.
What were you taught when it comes to erring on the side of caution?
So it was shortly after I had gone into the mailroom. At that time, it was Lieutenant C. Riley, who was the supervisor for mail. And he said with general mail, he would rather have me deny something if I had a suspicion there might be contraband, drugs on it, things like that. He said with legal mail, he would rather go the other way. He would rather risk having something come in than mishandling the legal mail.
So the policy, procedure, approach that you were taught anyway at DCCF was if there's any doubt when it comes to legal mail, then you protect the legal mail.
That was a verbal directive.
And we understand that there's policies and then there's also on-the-job training, correct?
Well, there's policies and procedures or guidelines. Like they can't cover everything. So yes, it was based on that verbal directive from the lieutenant.
And if you take a look at the handbook on page 2, under mission, there's a sentence that says, through honesty and integrity, we shall provide an environment that promotes respect, professionalism, and ethical excellence. Do you see that?
Yes.
Do you believe that this policy and procedure of erring on the side of caution when it comes to legal mail, do you believe it's consistent with that mission that I just read?
Yes.
Why?
Because part of our job is to follow the law, obviously. And we have the responsibility of having those people in our care.
You're in charge, not them.
Well, yes.
As part of your job as a mail officer, did you learn that some of Sterling Brown's legal mail had been opened?
Yes.
Did you write a report about that?
Yes.
What letter?
F.
F. Thank you, Judge. I believe F is a stipulated exhibit.
Objection.
F is admitted.
Do you recognize that?
Yes.
Can you tell the court what it is, please?
It's the report that I wrote on March 2nd, 2023.
Does it accurately identify the information you had and knew at the time?
Yes.
Why did you write up a report?
Because as I said, my verbal directive when I came to legal mail was to err on the side of caution, and his legal mail had been opened.
Is it your opinion that there was a violation of policy?
There was not a violation of policy.
We'll talk a little bit more about that. Let me back up a little bit first. Before this happened, before you wrote your report on March 7th, 2023, did Sterling Brown receive some pre-marked envelopes from his attorney?
Yes.
Can you tell the court what happened, please?
He received a manila envelope, and I don't recall if it was the day before or the end of the previous week. So I took that to him in the minute. I opened it up in front of him, pulled through the papers, saw the envelopes, and gave them to him.
So these are self-addressed stamped envelopes from Sterling Brown's attorney that were provided to Sterling Brown?
Correct.
And did it include paper as well?
I believe there were papers in there. I don't think there was like blank paper, but I don't recall. Again, I'm looking for contraband. I'm not looking at the contents.
Did you understand the purpose of Sterling Brown receiving those envelopes so that he could correspond with his attorney?
Yes.
So that was knowledge you had as the mail officer at DCCF?
Yes.
Was there anything wrong with that?
No.
Nothing wrong with an attorney sending pre-marked envelopes for the inmate to use?
Policy stated that if there was going to be postage on it, that it needed to be metered postage, which I believe these were.
And do you have the envelope in front of you there as well as an exhibit? Do you recognize it there?
I do not.
You see the envelope in there among the stack of exhibits?
Yes.
And I believe it's exhibit C. Is that envelope you see there, is that envelope consistent with the other envelopes that were sent to Sterling Brown?
Yes, this is one from that morning, and I'm the one who did the copy or scan of it.
So you're the one who made that copy?
Yes.
Is that the condition of the mail when it left your hands and left the facility?
Yes.
And so when that letter then made it to Sterling's attorney's office, that's exactly what it would have looked like, to the best of your knowledge?
Yes.
Do you recall how it had been opened? Like where?
I believe it was right along the top, and then I taped it up. As soon as I saw it, I taped it up with some Scotch tape.
When you say along the top, do you mean where the
Like the flap of the envelope, like if you were to use a letter opener, it would be like right along the top.
there's also an exhibit that should be in front of you, Officer Nichols, that's Exhibit D, which is a sticky note. Do you see that?
Yes.
Was that part of what you discovered as well when you came into work on March 7th?
Yes, it was stuck to one of those envelopes.
Tell the court what you did after seeing that sticky note and seeing the envelope or envelopes that had been opened.
The first thing I did was seal the two envelopes. I went to speak to Captain D. Riley. We didn't have a lieutenant at the time, so the captain was my next go-to. She wasn't in yet, because this would have been slightly before 7 or around 7 when I started my shift. She wasn't in, so I went down and spoke to Brown in the unit, explained to him what happened, told him that he should put his name and number somewhere around the return address so that we knew who they were for, but that I would address it with the captain so that we can ensure that it didn't happen again.
You knew the moment you saw these envelopes who they were from, correct?
Yes.
Was there any other inmate, to your knowledge, at DCCF at the time that was represented by that law firm?
I do not know, but as I said, when they came in, I'm the one who gave them to Brown.
Your report, Exhibit F, in the first paragraph says, quote, all 5 envelopes were signed off by Corporal Ellerton. Is that correct?
Yes.
And so we have an example there in the exhibit of one of them. Did they all pretty much look the same?
I can't remember specifically, but I would think so for me to have put that in my report that way.
Meaning all of the envelopes, all 5 of them, had been correctly signed off by Corporal Ellerton,
Yes.
consistent with the policy and procedure at DCCF, correct?
Yes.
And to be clear, that policy and that rule about it signing off by an officer, that applies only to legal mail, correct?
Correct.
So if you see a letter that's going out and it's signed by an officer on the back, even if it doesn't have a law firm letterhead or logo, that's legal mail.
Not necessarily.
Explain what you
So, again, it has to go to a court, an attorney. They have since added in paroling authority. It has to go to somebody like that. We've had some that try to send legal mail to their mom because they're sending them tax forms or maybe a power of attorney and things like that. Most of the time the officers, sometimes they'll look at the address, but for the most part, they're looking at the contents to make sure there isn't any visible contraband, and that's kind of what they're signing off on.
And so do you then do that second stage of review where you ensure it's being sent to an attorney or a court or something like that?
Yes.
And reviewing the envelopes here, are these correctly being sent to a law firm within the definition of legal mail?
Within the definition of legal mail, no, they are not,
Why do you say that?
because Brown's name and number is not on them.
So can you show me in the handbook where it says that legal mail that's been signed off by an officer is not legal mail if the inmate's name isn't on there? Is that anywhere in the handbook?
In the handbook, no, it's in policy 3.3.6.
And is it anywhere in the handbook or the policy that true legal mail can be opened?
If it meets the definition of legal mail, no, it must be opened in front of the inmate.
When you look at the envelopes there, do you recognize Ellerson's signature?
Yes,
And what did that tell you?
that Corporal Ellerton had signed off on them.
And I understand that the ink, it's kind of hard to see in the copy, that the ink was red.
Yes.
What's the significance of the ink being red?
Most of the time, us officers will use red when we sign off because the inmates aren't allowed to order red pens because we have had inmates forge signatures on legal mail before.
And did that happen here?
In Brown's case, no.
So what did you do after you ended up writing up a report? You ended up telling Captain Ridley. What else did you do?
Well, after I spoke to Brown, then Riley had come in, so I explained it to her, and I told her all my directive from C. Riley on the legal mail and how he had wanted it handled, and I asked her to address it with other staff so we could make sure that this didn't happen again. And then all 5 of his letters went out in the outgoing mail that morning.
How would you have treated that letter if it was your decision about whether or not to open it?
I would not have opened it.
Why not?
I had just seen those envelopes, so I was pretty sure who it was. I would have went and talked to him if I needed confirmation. Hey, Brown, were these yours? And I would have probably had him put his name and number at the top and let him know on future ones that he should do that as well.
And here, just to be clear, I think you already testified that the copy of the letters that you have in front of you as an exhibit, that's how they left your facility, correct?
Correct.
So you didn't go back and tell Sterling Brown, you gotta put your name and inmate number on these, correct?
I did. When I took the envelopes to him, I showed him that they had been opened. And I explained to him why they had been opened because his name and number wasn't on there, so he should make sure that they're on there in the future.
And
But that I would discuss it with Riley so we could address the issue as a whole.
And to be clear, did you make him put his name and number on them before you mailed them out?
I don't think I did, but I don't recall.
Your best memory is that the photocopy we have there is exactly how they were when they left the facility, correct?
Yes.
What was Mr. Brown's reaction when you told him his legal mail had been opened?
He was upset.
Did he explain why?
He said that it was his accounting of events that his attorneys had asked for, or something to that effect.
What did you interpret that to mean?
Basically that on whatever dates that were in question for his alleged crime, that it was his accounting of what happened during those dates.
A narrative of things?
Yes.
In other words, you understood that to mean Sterling Brown had described what had happened during the time of the alleged incidents for which he was charged.
That's what I assumed, yes,
And there were 5 envelopes, correct?
yes.
And there were multiple pages, correct?
They were all fairly thick.
And if there's evidence that's admitted that one of those letters was 60 pages, would that surprise you?
No,
Is it your memory that they were long letters like that?
I didn't even take the papers out of the envelope. I couldn't tell you. I just know that all the envelopes were thick.
And if Mr. Brown had written a narrative of events as he explained to you, can you think of anything more confidential than that for a person charged with a crime?
No,
And that's why you didn't read the letters.
correct,
You sealed them up and mailed them off.
correct.
Did you make any excuses to Mr. Brown for this?
I don't believe so. I just explained to him what happened, apologized, and said I would get with the captain, and we tried to make sure that this didn't happen again.
You apologized.
Yes, I think I did. It was 2 years ago, but
Yeah, I have no reason to dispute that at all. So explain to the court why you apologized.
because it's not the way I would have handled it.
And what about the fact that there's this, requirement that you're describing about having the inmate's name and number on there? Why would you apologize to Mr. Brown if it's the state's position that he didn't follow the rules?
Because that would have been based on my verbal directive that I received. It was contrary to that verbal directive and what the lieutenant at that time had wanted.
And that's why you didn't make excuses or downplay it. You owned up to it,
Correct,
even though it wasn't your mistake.
correct.
Did you ever talk to Miller, the officer who opened the envelopes?
I don't believe so. So he was a sergeant at the time, so he would have worked 6 p.m. to 6 a.m. And I didn't come in until 7. I worked 7 a.m. to 3 p.m. And I'm pretty sure we never discussed this incident. I rarely saw him.
There's a report from Agent Tucker in this case that says, and I'm just going to see if this is correct to your understanding. It says Captain Riley
Riley.
said she spoke with Miller briefly about the incident and told him to err on the side of caution in the future as it relates to legal mail. My question for you is that statement, if it's true, consistent with your training?
Yes, and I believe, I can't speak to a verbal conversation that she had with Miller. However, Captain Riley did send out an email to the supervisors. She included me in it, and she said the same thing. Basically, if there's a question, leave a note on it for Nichols, let her handle it, because we want to err on the side of caution with regards to legal mail.
What options were there besides opening this letter if you didn't know who it was from?
He could have put the sticky note on it and left it on.
And you would have known right away.
Yes.
What else could he have done? Any other options to your knowledge?
He could have spoke to Ellerton, because Ellerton would have, he was a corporal at that time, but he was on day shift, so he would have been in at 6 a.m. They would have passed in between shifts.
And do you see the sticky note there in front of you?
Yes.
It says at the bottom, Ellerton says they are brown in County A. Do you know what that is referring to?
My guess would be, so at some point previous in the night, they had opened them, and then when Ellerton came in sometime shortly before 6, he had asked Ellerton, and Ellerton confirmed that they were browns.
And that's just your best understanding there, do you know for sure?
That's how I'm reading the notes. But I didn't speak to Miller or Ellerton specifically about it.
And so if it was night shift, when Miller saw this and he saw Ellerton's name on there, all he had to do was wait until Ellerton came in the morning and he could ask him himself?
Yes.
Let me ask you a question about this handbook again. Take a look at page 4. There's a reference in here. Let's see. Page 4, bottom bullet. I'm not seeing it here, and I apologize. Is there a rule about people receiving envelopes?
Yes, for general correspondence, any envelope stamped stationery gets disposed of. However, if it's legal mail, and I'd make exceptions if it was not necessarily legal, but somebody needed to return some forms, policy states that the return postage has to be metered and not stamped.
And so if it says incoming mail with envelopes will be disposed of by the mailroom, you're saying that you make an exception to that rule for legal mail?
Policy has the exception, or had the exception for legal mail at that time. There were a few other exceptions that I made, but in policy it stated that there could be return envelopes for legal mail as long as the postage was metered and it wasn't like the sticky stamps.
I think it is time for us to take our lunch break.
I'm gonna hand you what I marked as Exhibit G. Do you recognize this document?
Yes.
Can you tell us what it is, please?
This is policy 3.3.6, which is in regards to offender.
This is the one you referenced before.
Yes.
Any objection to this one, Dan?
No.
Okay, it's admitted as G.
So I'd like to have you take a look at, well, first off, let me ask you, we heard some testimony in the earlier part of the case from Officer Ellerton about the process for inmates coming into DCCF and the fact that they're provided with handbooks and certain documents. And when they're provided with those documents, there's a record confirming that they received those documents. Is that your understanding?
I couldn't say for sure. It's been years since I have worked booking on a regular basis.
When you worked booking, was there some confirmation that went in the jail file that they received, for example, a copy of the handbook?
At one point, we had the handbooks actually attached to the wall in each unit, and that would have been at the time that I was working booking. I know at the time that Brown was there, they could get tablets, and all the policies were uploaded to the tablets.
Okay. And there should be some record somewhere showing that there was access provided to the inmate, though, correct?
I don't know what they kept for like the tablet records.
Very good. So the document that we looked at first, the handbook, the inmate handbook, that's a document available to the inmates and is kind of their guidebook for when they're at your facility, correct?
Yes.
And then this document, tell me how this document is different.
This document is, the policy and procedure is more detailed than the handbook is. We can't fit everything into the handbook because it would be as thick as all of the policies combined. So the handbook is more of a condensed version on like the most asked about things, whereas the policy goes more into depth.
Understand. And if you take a look at page 3 of this document under number 7, it says outgoing offender correspondence, including legal, privileged, and general, must display the return address as well as the offender's last name and number. Is that correct?
Yes.
And then the very next sentence says, quote, correspondence will be disposed of if the inmate sending the general correspondence cannot be identified, correct?
Yes.
And so if I understood your testimony earlier, it's your interpretation of the rules that if something doesn't meet all the requirements of legal mail, then it may be considered general mail.
Correct.
And then this says if you don't have a return address on general mail, it will be disposed of if the inmate sending the general correspondence cannot be identified.
That is what it says here.
Is there anywhere in this document that says if you can't find the inmate's name, that DCCF has the right to open the envelope and scan it or read it?
So on C, page 4, section C on the outgoing legal correspondence, number 1, in order to be accepted and processed as outgoing legal or privileged correspondence. I'm sorry. So on C, outgoing legal correspondence, 1, in order to be accepted and processed as outgoing legal or privileged correspondence, the mail must comply with the following requirements. And that goes on, must meet the definition of legal mail, which was on the front page. If the addressee does not meet the definition of one of the entities noted in the definition of legal or privileged, the mail will be handled as general correspondence. B, the inmate's name, full name, DOC identification number, and the address of the facility shall be included in the return address on the outside of the envelope. C, the front of the envelope must be clearly marked legal mail or privileged mail. Outgoing legal or privileged correspondence shall be presented unsealed to designated staff by the inmate. In the presence of the inmate, staff shall inspect the enclosed correspondence by shaking the pages to ensure no contraband is hidden. Staff shall not read the enclosed correspondence. So in order for it to be legal correspondence, it needs to meet both all A, B, and C.
Yeah, and I understand that, and I appreciate that. My question is just a little bit different. So if it doesn't meet those requirements and therefore becomes general mail, where does this document say that general mail can be opened if there is no inmate name on it? Because all I'm seeing is that it says that the correspondence will, quote, be disposed of.
In section A on page 3, inmate mail requirements, authorized personnel of Dawson County Correctional Facility may open, examine, or censor mail sent from or addressed to an inmate in accordance with the United States Postal Administrative Support Manual.
So is it your understanding that that's where you're warning inmates that the mail can be opened if it doesn't have their name on it?
Yes.
Is there anywhere else that says that as far as you know, officer?
Not that I can think of offhand.
And just to be clear, when you brought these envelopes to Mr. Brown when they first came in, you didn't instruct him specifically to put his name and return address on there, did you?
Not that I recall.
And Officer Ellerton testified that when he took those legal mail, those envelopes from Mr. Brown and signed the back, likewise, he did not instruct Mr. Brown to put his name on it. Do you have any reason to disagree with that?
No.
And then when you mailed out the letters yourself as the mail officer, you didn't have Mr. Brown put his name on it either, correct?
I don't believe I did.
Okay. One question about, is there a jail kind of video courtroom and meeting place where inmates have an opportunity to meet with their lawyers and have attorney phone calls?
Yes.
What's your understanding of the ability to audio and video record in that room? Do you know?
As far as I know, the only thing that records audio or video is the setup for the Zoom, which used to be the VisionNet.
And so that's kind of the jail court, the ability for the inmate to communicate with the court and for them to go back.
Correct.
And so there is audio, video, at least in that capacity.
When it's connected, yes.
I'm going to hand you what we marked as Exhibit H. This is a stipulated exhibit. Do you recall having an interview with DCI agent Brad Tucker?
Yes.
And do you recall that he recorded that interview and told you he was doing that?
Yes.
And I'll represent to you that Exhibit H is a copy of the transcript from that interview, just so that the court has a complete story here about all questions and answers that were provided. Is there any other information, officer, that you believe is important for the court to understand when it comes to this jail mail issue?
Not that I can think of.
And besides the one instance where you opened up a letter that was coming in from a court to an inmate and immediately recognized that it was a court pleading or some document, are you aware of any other incident at DCCF besides Sterling Brown where legal mail to a lawyer was opened?
No.
Thank you very much.
Attorney has provided their client who's been housed at Dawson County Correctional Center with an envelope that lists both the return address and the address to address as the law firm.
I can't think of a specific one off the top of my head, but it's very possible.
Would you agree that the policies and procedures dealing with mail are summarized in the inmate orientation manual?
Yes.
And that is provided to the inmate either in paper form or, in this case, perhaps on an iPad, is that right?
Yes.
Is there any reason to believe that Mr. Brown did not have access to the orientation?
No.
And then a more comprehensive version of that is in your policies and procedures, is that right?
Correct.
And that clearly states to be legal mail, the inmate must put their name on the envelope, correct?
Correct.
Their CF number.
Yes.
They must also mark it as legal or privileged mail. Can you explain that to the court?
It's to make it obvious that it is legal or privileged correspondence.
And is that pursuant to the regulation you mentioned earlier,
3.3.6, it is in there, yes. The only exception in policy on not having it marked as legal mail is incoming from the courts. Policy does specify that even if it's not marked as legal, if it is coming from a court, we still treat it as legal.
And could you clarify for the court what ability an inmate has to access that document, the larger rules and procedures?
At the time that Brown was there, they were on the tablet. We had the Adobo tablets at that time. And there was a way for us staff to log in basically as an inmate and another staff member, and I had looked through those tablets and we did see the policy online. If I remember correctly, in order for him to get a tablet, because we didn't have enough for every inmate, they would sign up and request a tablet, similar to how they would with razors or mail orders.
And what about individuals that are representing these inmates? What ability do they have to access these documents?
I believe our policy was on the state of Montana's website at that time. And if our policy wasn't, the policy for the Department of Corrections, MSP policy, was online.
Certainly, have you been requested by defense counsel, the policies and procedures?
No.
Okay. But if somebody made the request, you would be able to provide it?
Yes, and I have been asked on other occasions, family members calling in wondering what the policies were. And I would direct them to the state of Montana website and tell them how to get there. That has recently changed. The way we do policy, or the way we process mail, has varied enough in the way the Montana State Prison does mail that our warden recently added our specific policy to our county website.
And so in this case, it appears to me that Mr. Brown did not comply with the policies and procedures of outgoing legal mail, is that right?
Correct.
But you also testified that if you were in Captain Miller's shoes, you wouldn't have opened those mail, is that right?
Correct.
Had the policies and procedures been followed, where Mr. Brown's name and CF number and designation as legal mail was placed on that envelope, do you believe that anybody would open that envelope?
No, so all of the county outgoing mail gets logged. I log all of the incoming and outgoing legal mail. What I got from Miller's Note is the reason they opened it, to try to determine which inmate it came from was so that they could log it.
Earlier you said that there's a regulation you looked for in the larger policy manual that stated that general mail, non-legal mail, could be searched. Where is that at in the policies? Is that under section E, did you say that's, or is there another section?
General mail, it's A, inmates mail requirements on page 3. At the top of the page.
Okay. And that states that if it's not legal mail, it's going to be treated as general mail, is that correct?
That is the one that says that we can read open and censor mail. It is section C that starts on page 4. That says in order to be accepted and processed as outgoing legal or privileged correspondence, the mail must comply with the following requirements. And that is where it says it needs to meet the definition of mail and have the inmate name number.
So what about E later on? I believe it's page 2062. E1, what is that referencing then? It says designated staff may open, read, photocopy, or examine incoming and outgoing general correspondence for contraband.
That would be the other place where it was. So again, that's saying that we can open, read, photocopy anything that's general correspondence. And if something's not considered legal mail, then it is considered general correspondence.
And based on these regulations, in the technical aspect of this, not in colloquial terms, but in the technical terms of what is definition of legal mail, Mr. Brown's letters do not meet the requirements of legal mail, is that right?
Correct.
And therefore they would fall into general correspondence, is that right?
Correct.
Which would allow you to open that, right?
Yes.
I'd like to talk to you about, your understanding is that Officer Ellington received the mail from Mr. Brown, is that right?
Well, he wouldn't have received it from him. What most likely would have happened is Brown would have stopped him when he was walking, when Ellerton was doing a walkthrough on the pod, said, I have legal mail. Ellerton would have said, okay, show me the inside. He would have kind of flipped through the pages to make sure there isn't any obvious contraband. He would have had Brown put the papers back in the envelope, allowed Brown to seal it, and then after it was sealed, he would have signed off on the back.
Okay, and the sign off the back just means he inspected it for contraband, is that right?
And that, yes, and that is so that I know that an officer inspected it when it comes to me.
Right, good. If you could go to the orientation document. And it says, this would be Defendant's Exhibit B. You may not, do you have that in front of you?
Yes.
B, thank you. If you look at page 4, there were some questions by defense counsel about scanning and not scanning, whether it was stated in the policy manuals. But if you look at page 4, it is the 4th bullet point from the bottom, and it states, legal mail will be opened in the presence of the offender and a visual scan for contraband will be conducted. Is that right?
Would that be that would be for the incoming, correct?
It's page 4,
Okay.
and it's under, I believe they're talking about outgoing mail above it. And what I'm reading is, right above it, it says, all incoming and outgoing mail will be inspected for contraband. The introduction of contraband is a felony. Violators will be prosecuted. The next bullet point, the 4th from the bottom on page 4, and this is the orientation one. It says legal mail will be opened in the presence of the offender and a visual scan for contraband will be conducted. Are you saying that's only for receiving the mail? The scanning?
No, it would be the same for the outgoing. It's just, like I said, it's a visual scan to make sure that there isn't any contraband.
Sure. I was just trying to clear up, because I think you said, maybe I'm wrong, that the word scan wasn't used in the policy here. I just wanted to clear that up, that it is used there in terms of a visual scan.
It isn't in the new policy. They have changed the wording. I think now it says it's visually inspected instead of scan.
Thank you. So from Mr. Ellington, or Officer Ellington, it goes to a mailbox or some sort of mail area, is that right?
Brown should have put it in the pod mailbox after Ellington had signed off on it.
Okay, but that point is not open yet, right?
Correct.
It's sealed, right?
Yes.
Per Ellington's signature. And then at some point, Captain Miller looks at it, right?
Sergeant Miller, so what would have happened sometime after lockdown, whoever was working booking would have picked the mail up out of the pod mailboxes. And then they sort kites or inmate requests, they take those, put those in the mailboxes of the appropriate staff. There's a place down in booking where they usually put the outgoing mail, but I believe whoever picked up the inmate mail that night then took it to Sergeant Miller.
And presumably it's not opened at that point either, right?
That would be my guess, yes.
And then Sergeant Miller, not seeing that it fits the criteria for legal mail and there's no return address, opens it up, is that right?
That is what I understood from Miller's note, yes.
And he actually is very transparent that he did this. He leaves a note saying he opened it up, is that right?
Yes.
And then, do you have any information that the contents of those envelopes, and it's 2 envelopes, right?
There were 2 that were opened, there were 5 in total.
Yeah, do you have any information that anybody read those letters?
No.
And despite Sergeant Miller opening 2, he didn't open all 5 of them, right?
Correct.
He opened 2, and then once you realized it was open, you went and told Mr. Brown, is that right?
After I sealed up the envelopes, I attempted to talk to the captain first, but then yes, I went and spoke to Brown, and it was probably right around 7 or so.
So not only is Sergeant Miller leaving a note to be transparent, you're being fully transparent with Mr. Brown about the fact that they were open, is that right?
Yes.
And then you even read a report about the incident, right?
Yes.
And do you feel like you were very transparent about this issue?
Yes.
Do you know of anybody that ever read the contents of those letters?
No.
When you have these envelopes, and I think it's a normal type envelope, do you think 45 pages could fit in an envelope?
Probably not. They would have been very difficult to seal normally, and I don't recall seeing any tape that would have helped to seal them. I do know they were fairly thick, but I couldn't tell you how many pages were in each.
Now, you work for Dawson County, is that right?
Yes.
And that's a separate county from Prairie County, right?
Yes.
Do you have any interest of knowing what is in an inmate Sterling Brown's letters to his attorney?
No.
Does any of your fellow officers have any interest in this case against him?
No.
I'd like to talk to you about the room that you were asked about where an attorney, from what I understand, an inmate and an attorney can meet in a private room and talk about their case, is that right?
Yes.
But not only can they meet in a private room, they can also have a phone call between each other in that room, is that right?
Yes.
And you were asked earlier whether there was any audio taping of that, and I think your answer was no, is that correct?
Correct. So they use, if it's a phone call, we have a regular phone, not an inmate phone, that I think they keep it in the cupboard and they pull it out when they need it. To my understanding, it's just a regular phone. The audio and video recording would be, there's a TV screen with a computer, and that's only running when we're doing actual Zoom court or something like that.
Which is somewhat infrequent. There's plenty of opportunity for inmates and attorneys to talk over the phone in privacy under that scenario, is that right?
Yes.
And if you have any difficulty with that arrangement where defendants can talk to their attorneys over the phone in that room?
If there's already court going on, however, we do have I believe, 2 visitation booths that have non-recorded lines, and those are always given priority to the attorneys.
Okay. And there's no charge for those lines?
No.
Do you know whether or not, and maybe you don't, but do you know whether or not Mr. Brown and anybody from his law firm ever took advantage of that opportunity to talk in private without a cost?
I do not.
Okay.
I wasn't working county side at that time.
Okay. Have you ever heard anybody either discussing the contents of any calls that Mr. Brown made to his attorneys?
No.
Have you ever heard anybody discussing that they read the open envelopes or those letters that were written to his attorney?
No.
You believe anybody ever read them?
No.
When you talked about the sanctity earlier, about how important it was for attorney-client privilege to be intact, so that, I mean, really, you're an important part of that with the mail and also with the other detention officers, is that a defendant can use, has a benefit, his constitutional rights to an attorney, and really that has to go through your institution to make sure that that's intact. Is that right?
Yes.
In this case, with the fact that it may be that nobody ever shared that information among each other or with law enforcement, do you believe the defendant's rights to attorney-client privilege, do you believe that he was prejudiced at all by this?
No. As per policy, it did not meet the definition of legal mail. Our policies are based on policies from the Montana State Prison. I know that at least for their mail policy, they go through their legal department before they approve those policies. Now, recently ours has differed a bit from theirs just because all of the incoming general correspondence now is scanned and uploaded to their tablets. There's differences between us and MSP and how they do it. And some of the other things that we handle, they're just different. So now ours is more separated from theirs than it has been.
I think it's been widely established that you are the person that knows everything, all things related to mail at your Dawson County Correctional Facility. Is that right?
I'm the one who probably knows the most, yes.
Okay. After this incident happened, after you talked to Sterling Brown and he said that this happened, and you showed him that you taped up the letters and they were going to go out, had you ever talked to anybody from the defense team about this matter at that time?
No, I don't believe so.
Prior to today, have you talked to anybody from the defense team?
No.
Nobody came back after this alleged mishap and asked you about the procedures and the processes at the jail?
I spoke with that investigator.
With the
I don't, there was an investigator that showed up and I was told to talk to them.
Is it that guy maybe?
It could have been.
Yeah. But nobody called you on the phone and asked you for clarification on the procedures?
Correct.
Okay.
And just for the record, that was Agent Tucker who looked over, that maybe the gentleman you spoke to.
I think it could have been.
Thank you. I want to ask you one last question. We have Officer Ellerton involved. We have Sergeant Miller, I called him Captain earlier, Sergeant Miller, and we have you. It appears that Officer Ellerton didn't open the letters, right?
They would have been presented to him still open, unsealed.
And then he would have sealed it with it, and we know that piece of
He
signature, right?
probably would have had Brown seal them up and then Ellerton would have signed off on it.
So based on your knowledge, there's no issue of Ellerton ever reading the letters and going through the letters, is that right?
Right, because Brown would have seen him if he had done that.
And then it appears that Sergeant Miller opened the letters, is that right?
Yes,
And there's no information that you know they read the letters, right?
correct.
And then they were presented to you with a note and then you saw them and you never read the letters, right?
Right, I didn't even take the papers out of the envelopes.
And so are those the only people that you believe, you and Sergeant Miller, that would even been presented when they were opened?
Most likely, possibly whoever was working booking that went to, that took those envelopes to Sergeant Miller and probably said, what would you like me to do?
But they wouldn't have been opened by that point, right?
Correct.
So really only Sergeant Miller and you had access to those opened envelopes, is that right?
Most likely.
And you have no knowledge of anybody reading the letters, right?
Correct.
And I know it seems like you would logically follow, but if you don't have any knowledge of anybody reading the letters, you don't have any knowledge of anybody sharing the contents of those letters with the investigators in this case. Is that true?
Correct. And I didn't hear any rumors on contents of the letters.
Okay, one moment, Your Honor. Maybe some additional questions, but I have no further questions. Thank you.
Side of caution when it comes to legal mail is because you can't unring the bell, right?
Yes.
Now, once a legal mail's been opened, possibly reviewed, scanned, or read, you can't undo that, right?
Right.
And it's particularly important when you're talking about what Mr. Brown described to you as being the contents of these letters, right?
Yes.
And when he told you, I wrote a narrative of the events surrounding this alleged crime, you knew that that was important to him.
Yes.
And you knew that was sensitive.
Yes.
And you knew there was a violation of the policy in your mind because you wouldn't have opened these envelopes.
It was a violation of the verbal directive that I was given, yes.
And the verbal directive being from your predecessor, the prior mail officer at DCCF.
No, from my prior supervisor as me being the mail person.
Right. And you were asked some questions about whether you've been contacted by our team prior to today. Do you have any idea about whether or not we requested the ability to talk to you and whether that issue is one for the court to decide?
No, I do not. I got a subpoena a week and a half ago, so.
Understand. So the entire justification for opening these letters, as I understand it, was for the log, right? The mail log?
That would be my guess, yes, based on Miller's note.
I believe this is a stipulated exhibit, Your Honor. You'll give.
What is it? I'm sorry, I don't know.
Oh, sorry.
Thank you.
Yeah, no worries. I believe this is exhibit I.
This is stipulated to you. I think it should be sealed, though. It has a bunch of private information on a bunch of inmates, so I think that would ask that it be sealed.
Objection. Okay, so exhibit I will be able to have stipulation, but it will be sealed.
So this is the mail log.
Yes.
Do you see Mr. Brown's indication on there for that day?
Yes.
And so you were able to then successfully log his mail as outgoing mail?
I don't believe I logged that.
Who did, do you know?
The log should be bigger than this, and there should be a chip number on there. I don't remember if it's on the right or the left. It's been a while since I've logged in the actual county mail log.
Is it consistent with policy or not consistent with policy if Mr. Brown mailed 5 letters that day for there to be only 1 entry in the log?
I would say no.
So that would seem to be a deviation from the procedure, at least as you know it.
Like I said, it's been a long time since I have done the county log. I would have logged each of them individually.
Okay. And then lastly, I just want to touch briefly on these policies to make sure I understand correctly. You were asked about So I'm looking at Exhibit G. That's the longer policy, what you refer to as the 3.3.6, or at least the one that includes that. Do you have that in front of you?
Yes.
And on page 6 of that document, under general correspondence requirements, you were asked questions about this, and it says designated staff may open, read, photocopy, or examine incoming and outgoing general correspondence for contraband, right?
Yes.
So just to be clear, there's no contraband issue when it came to Mr. Brown's letters that were opened, correct?
But there was no visible contraband.
Ellerton didn't find any?
No.
You didn't find any? No. And so the only provision then that would provide warning to Mr. Brown that the facility may open mail if it doesn't have his name on it would be this one on page 3A1. This is the one that refers to the United States Postal Administrative Support Manual, correct?
That one and the other one that you referenced to is that it could be the designated staff can open, read, inspect.
For contraband.
Yes.
So what you're saying is that either contraband issue or someone at the facility is supposed to read A1 and this reference to the United States Postal Administrative Support Manual, and then know from that if legal mail doesn't contain the return name, it can be opened. That's as clear as the policy gets.
I think the definition of the legal mail is pretty clear.
But as far as the ability to open it, that's the provision, right?
All mail is subject to, all general correspondence is subject to being opened, read, photocopied, examined, and it has to comply with the rest of the mail policy on what's not allowed in there, along with our other policies as well.
And despite all of those policies, despite all of the information, despite all of the testimony, it remains your position as the mail officer at the facility that you wouldn't have opened them, correct?
I would not have.
Thank you.
I asked you about whether anybody contacted you. I understand that they maybe kind of led into whether they contacted you for this proceeding today, but I'd like to be more specific. Back when you talked to Sterling Brown and you said that his mail was open, during that time period, did anybody contact you that represented him to follow up with you about the proper procedures and policies regarding mail at the Dawson County Correction Center?
Not me personally. I do believe somebody called and spoke with Captain Riley.
Okay, do you know who that was?
I do know.
Okay, thank you.
Good afternoon. Good. Thank you for being here. Have we ever met before?
No, not to my knowledge.
Would you tell the court a little bit about your background, and we don't need every detail, but just since high school, major jobs, employment, things like that, please?
Graduated high school in 2002. I joined the Air Force in 2003 until 2009. Came back to Glendive in the beginning of 2009. Joined Dawson County Correctional Facility in 2010 until I think September of 2024. And I'm now employed by a Thatcher company.
What's that?
Chemical company in Glendive.
Can you tell the court a little bit about your the different roles that you had at DCCF during the, I guess, about 14 years that you worked there?
I couldn't give you the lengths of time, but I was served as a correctional officer, a corporal, and a sergeant out there.
Were you an officer at the facility when Sterling Brown was there?
I was, I believe I was a sergeant at that time. I might have been a corporal. I'm not sure. I can't fully remember my days when I was on.
Do you remember Mr. Brown?
Vaguely.
You understand that he was an inmate on what I understand is referred to as the county side or the jail side?
Correct.
Did you receive any special instructions as it pertained to Mr. Brown when it came to monitoring his communications or anything like that?
Not that I'm aware of.
If timing wise in 2023, when Mr. Brown was there, if you were working as the shift sergeant, would that sound about right?
Yeah, that would sound about correct.
Would you have been one of the most high-ranking officers in the facility when you were on shift?
Yeah, I would have been the supervisor on shift. I worked nights, so there was no other administration above me at those times.
Night shift, the warden and the deputy warden are not there.
Correct.
So you're the top person in charge at that point in time. And how many people would you have working underneath you on a typical shift?
That time frame, would have had a corporal and a few officers. Excuse me. I couldn't give you the exact amount of officers I had on shift around that time because there was a lot of in and outs of officers at that time frame.
And what was your role as shift supervisor then? I mean, just give us a general description of what your job duties were when you were on shift at that point in time.
Would have been supervising the facility, both state and county side, supervising my officers and the inmates in the facility.
Did you have any law enforcement or detention officer role when you were in the Air Force?
I had served with security forces off and on, but nothing pertaining really to corrections or anything like that.
Did you receive any training when you were in the military about the attorney-client privilege and the importance of protecting that privilege there?
No, but I do know the gist of it, yes.
That's something that's, I understand, is drilled into the heads of people who work at the detention center.
Yes, sir.
Something that officers are expected to know, learn, understand, and apply from day one.
Yes, sir.
No exceptions.
Sure.
Now, you understood at the time that Mr. Brown was in your facility that he was charged with a serious crime.
I knew that he was charged with a serious crime, but while I worked at the facility, I didn't look at people's crimes. I focused on how they acted while they were in the facility.
And your job is to keep everybody safe and things like that, right? Now, we've heard testimony about an incident on what would have been March 6, 2023, where you opened a piece of legal mail from Sterling Brown. Did that happen?
I vaguely remember what's the discussion.
We've received and exhibited evidence from Officer Nichols, the male officer. Do you know her?
Yes, I know Officer Nichols.
And was she the male officer in charge of the mail system there during the entire time you worked at DCCF?
I believe there were two officers before her that I worked with that had that role prior to her.
And I'll probably butcher the name because there's a Riley and a Riley maybe, but was there a predecessor male officer before Nichols with a name like that?
In charge of mail?
Yes, sir.
No.
Who was the predecessor officer in charge of mail before Nichols?
I believe that would be Dr. Danielle Doctor, I think is her first name.
Okay. During the time that Kay Nichols was at the facility, she's pushed back on this label, by the way, but I think the general agreement is that she is the most knowledgeable person, if not the guru, of legal mail and mail at the facility. Would you agree with that?
She would be the one to go to for questions regarding mail.
Including for you?
Correct.
Because you have a lot of things you're in charge of taking care of, right?
Yes, and handling mail and opportunities to her is not the least that I deal with it.
Right, and this mail issue is important enough that DCCF has a person whose job is dedicated
to that position, right? And you knew that at the time?
Correct.
And you knew you could go to her if you needed input, assistance, or anything like that?
I could get a hold of her.
Yeah, and we heard some testimony from some other officers that there was a phone list available. So if you needed assistance from another officer and they happened to be off shift, you could pick up the phone and call their cell. Yes?
Correct.
And did you do that from time to time as needed?
As needed, yes.
So if you take a look, there's an exhibit in front of you that should be marked as Exhibit C, and it's an envelope. Do you see that envelope there? There you go. The testimony that we've heard so far is that that's an envelope that was opened by you. Is that correct?
I seem to recall, yes. I've been away for a while, and with this being a little before that, I have vague recollections of.
No, and that's fair enough. And let me call your attention to another exhibit that should be up there for you, which is Exhibit F. It's a one-page report from Officer Nichols about this incident. Do you see that up there in front of you?
The report?
Yes, sir.
Yes, sir.
Have you had a chance to look at that document before you came in to testify here today?
No, I haven't.
Why don't you just take a chance and just read it to yourself so you're kind of familiar with the lay of the land here, and then I have a couple questions for you, okay? See that? Anything you disagree with in that report, sir?
No, I wouldn't see anything.
Do you have a memory of opening one of Mr. Brown's envelopes? I mean, do you have a specific memory of that as you sit here today?
I vaguely remember what's being discussed.
Okay. And as you look at the envelope there, do you see a law firm logo there and a name of a law firm listed there?
I missed that.
And do you see that there's a signature on the back of the envelopes?
Yes, sir.
Do you recognize the signature?
I do.
Whose signature is it?
That would have been Corporal Howard.
Is that a signature that you'd seen before?
Yes, I've seen that before.
So you knew who that was?
Correct.
And what did it mean to you, understanding you're not the male officer, but as a shift sergeant, what did it mean to you when you saw that envelope with the law firm logo on there and a name with Ellerton's signature and badge number on it?
That he had signed that it was legal.
And what process does that mean? I mean, are you familiar with that signing off process?
I still remember parts of it.
Is that something that you yourself did as an officer at one point in time?
Yes.
So you'd signed envelopes like that before?
Yes.
And that signified to you that the letter had been inspected for contraband, found to not be contraband, and then signed by the officer who was looking at it after it was sealed into the envelope.
Correct.
All in accordance with the legal mail program, right?
Yes.
And that legal mail requirement, the signature on the envelope requirement, that doesn't apply to general correspondence,
No.
just legal mail. And so when you saw that envelope there, you knew it was legal mail.
I believed it to be such, yes.
And when you are in the process, like Ellerton was, of checking legal mail for contraband, I believe you told Agent Tucker during your interview that you are not allowed to peruse legal mail. Is that correct?
Correct.
And what did you mean when you said not allowed to peruse legal mail?
We are not allowed to read through it.
Just the goal is to flip the pages and ensure that there's nothing like contraband in there.
Correct.
That's it.
This is to my knowledge.
And that provision you understood at the time was important to ensure that the attorney-client rights of the inmates are respected, correct? And that was important.
Correct.
Did you ever have a concern that Sterling Brown's letters had contraband in them after seeing Ellerton's signature on them?
No, I did not.
Was Ellerton an officer you worked with before?
Not on a steady basis, but we had worked together on and on.
Was he an experienced officer?
I would say so.
Somebody you trusted at the facility?
I trusted all my officers I worked with.
Now, despite understanding that was a legal letter in that envelope, you opened it, right?
Yes, I believe I was the one that opened it.
And the reason you opened it was just to see who it was from, correct?
I was trying to figure out who it was being sent by to fill out our logging system.
And there's an exhibit there. It's kind of a color-coded table of a mail log there. Do you see that somewhere in front of you, sir? Yes, sir. Is that the log that you were interested in filling out?
Correct.
Do you know why, as you look at that log here today, that there's only one entry if Mr. Brown mailed 5 letters that day?
I wouldn't be able to explain that, no. Excuse me.
Do you know if the log was required? The mail log? Is that a required step in DCCF or not?
I believe it was required. One of the steps is to retrieve mail and log it.
And I know it's been a little bit of time since you were interviewed by Agent Tucker in the case, so we have a transcript of your interview there, okay?
No objection, Your Honor?
Exhibit J. Okay, great.
Exhibit J is clear.
Do you recall being interviewed by Agent Tucker?
I remember being interviewed. I couldn't tell you the name of the interviewer.
And is it fair to say that if you were interviewed on December 1st, 2023, that was more recent in time to the events than now?
Yeah, it was more recent.
And do you have any reason to doubt the information that you provided in your interview with Agent Tucker?
I don't.
So if you take a look at page 6, about 4 or 5 lines down, the question is, but your purpose of opening this was, and you said, just to see who it was from, so that we could log it on our outgoing mail log. Did I read that right?
Where is that at?
About six lines down from the top on page 6.
Okay.
You see that?
I see. What was the question?
Just whether I read that correctly. That the purpose of you opening up was to ensure your mail log was complete. Is that right?
Yes, sir.
And then the next question is, and that is that required of you to log who it is on that outgoing mail log? And your answer was, I don't know if it's required of us, but we normally Yeah.
Yes, sir.
And is that accurate that you don't know or didn't know at the time whether the mail log was required?
I didn't know full mail policy and procedure by heart at that time, so I wouldn't be able to tell you if it was required in there or not.
So at least at the time that you provided the statement, you weren't sure whether the mail log was required, but to be fair, that was your justification for opening the letter, is to see who it was from, correct?
In order to fill our mail log, correct.
Now, is there anything that prevented you from calling Ellerton on the phone to ask him whose mail that was?
No.
And did his shift start when your shift ended?
I don't know if he picked up the mail, he would have been working in my shift.
Is there anything that would have prevented you from asking him if he were coming on to shift when you left, or if you were working the same shift with him?
No.
And likewise, is there anything that would have prevented you from contacting Officer Nichols, the mail specialist, and asking her what to do in this scenario?
No.
She's testified that she would not have opened the letters. Are you aware that that's her position?
I'm not aware of this.
Are you aware that she was trained that you need to err on the side of caution when it comes to protecting attorney-client letters, even if there's some question about what's happening?
I couldn't testify to what she was or was not trained on, or how she was trained on those.
Were you trained to err on the side of caution when it came to legal mail?
I understood the client attorney privilege, but I did not receive specific mail training, handling of that sort.
We've heard that there's a small pool of, or smaller pool of inmates on the county side or the jail side as opposed to the prison side. Is that fair?
Oh, absolutely.
And we also have heard testimony that this letter would have come from the county side or jail side, right? So was there anything that would have prevented you from going to those inmates, approximately 20 inmates or whatever the number was, and ask whose letter it was?
Other than the fact that it was past lockdown and I couldn't speak for what was going on at the current time.
Was there any time-sensitive need for this letter to be opened?
Other than having it filled out, depending on what day it was, if we were done for the week or anything like that, I didn't.
And presumably there are issues that come up when you were working at DCCF that did involve time-sensitive issues, safety issues, contraband issues, things like that. But this was not one of those issues, correct? Now, if we take a look at page 3 of your statement to Agent Tucker, it sounded like you opened the letter and then you scanned the letter. Is that what happened?
I believe I was looking for like a signature or a name from the senator.
I looked for a name on the letter, right?
Correct.
And then the question, after that long answer you provided, the question from Agent Tucker was, so did you locate a name on that? And your answer was, yes. And then down below you said, I believe I saw either a Mr. Brown or a Sterling Brown on there. Is that correct? So in order to look for those words, you were having to read words, right?
Not specifically reading in depth, but just scanning for like a key name or something that would stick out to who the letter would have come from.
Right, and I mean, you can't look for a name without reading some of the words, right? Agree with me on that?
To an extent, yeah.
You recall how thick the letter was?
Oh, I do not remember that.
If there was testimony from Officer Nichols that it was a thick letter, would you have any reason to dispute that?
No.
And then your testimony to Agent Tucker was that you believed you saw either Mr. Brown or Sterling Brown towards the top of the letter or towards the bottom of the letter, correct?
That's what it is here.
And that's how you knew it was from Sterling Brown, right?
From what I can remember, yes.
I want to have you take a look at a different exhibit that should also be in front of you. It's a sticky note. Photocopy of the sticky note. Do you see that document, sir?
Yes, sir.
Do you recognize that? And this is exhibit D as in dog.
I can vaguely remember it, but I think that is my signature on it.
Okay. Did you write this entire sticky note? Is that all your handwriting?
It appears to be my handwriting, yeah.
Nichols, we opened these two envelopes to see what they are, but we were unable to and didn't want to open them all. Did I read that correctly?
Envelopes to see whose they are.
Okay, thank you. But we were unable to and didn't want to open them all, right?
Yes.
So I'm having a hard time understanding how, if this says you were unable to determine whose they were and didn't want to open them all, then why you told Agent Tucker that you were able to see Mr. Brown's name, Sterling Brown or Mr. Brown, on the letter itself. Can you explain that?
I would possibly be because of the extent of time between there that I believe I saw his name, but I must not have.
I'm sorry, I didn't hear you, I'm sorry.
I didn't have these to go through at that time, and I could have made the mistake of thinking that I had saw it when I was doing the interview.
And then down below your signature, Ellerton says they are Brown in County A. That's something you wrote as well?
Correct. Looks like my handwriting did.
Do you know the circumstances that led you to write that?
I believe Ellerton informed me that he thought they belonged to Brown.
Did he tell you that face to face, or how did that happen?
I believe he in the office or face to face.
So
I can't. Like I said, it's been a significant amount of time. I honestly don't remember exactly the exact going ons that happened pertaining to this.
Page 3 of your statement to Agent Tucker at the bottom, third line up. The question is, do you remember how many letters there were or how many letters were opened? And what was your response to that question?
Looks like I stated that it was only one.
And the sticky note with your handwriting that you wrote says that you opened 2 letters, correct?
Correct.
Do you know which is true as you sit here today?
I would probably go with what's on the sticky note, as that's from the date that it happened.
And likewise, if that's what Officer Nichols wrote in her report, that there were 2 letters opened, you wouldn't dispute that now, would you?
No.
And one of the things that you explained on page 4 of your statement, when you said that you'd only opened 1 letter, and I'm looking at the top of page 4, sir, third question down, or third part down, you said, I don't believe that I opened 2, because if I had seen that the letters, stamped like it or not, addressed as it was, I would have counted the other if there was multiple more as being from the same to the same. And in other words, if you have 5 identical letters or envelopes, all addressed the same way with the same law firm logo, the same addressing name, you don't need to open all of them to understand that they're from the same person, right?
Correct.
So can you explain why you may have opened 2 of those letters now?
I couldn't give you an honest answer correctly now.
Okay.
I don't know what my judgment was at the time.
One of the things you wrote on the sticky note is that we opened these 2 envelopes. Do you know who we is?
I believe that would have possibly been myself and Corwell at the time, but I don't remember exactly.
And if Ellerton testified that he was not there when the letters were opened, would you have any reason to dispute that?
I obviously don't remember, so I wouldn't be able to dispute or acknowledge it.
And as far as we, the one thing we do know is that the we doesn't mean Mr. Brown. Like, he was not there when you opened these up, correct? Had you ever opened a legal letter before?
Not to my recollection.
Have you ever opened one since?
I don't believe I did.
Have you ever seen a policy or rule from DCCF, written or unwritten, that allows a detention officer to open legal mail?
I don't remember policy or procedure from the facility.
Well, one of the things you were asked about by Agent Tucker is what your policy or practice was when an inmate maybe started talking to you about their lawyer. And I don't mean on a phone call, I don't mean on a letter, I mean a face-to-face interaction. And what you would do in that instance is the moment the inmate starts talking about their case, I have a line. I'm not your lawyer, I can't talk about your case.
Correct. Those are usually my steps.
And that's because you were doing everything you could in that context to avoid a situation where an attorney-client piece of information might come out, right? Because while you as detention officers may have a lot of training in the policies and the procedures and the laws and the privilege, that's not necessarily the same for the inmates there, right? Thank you very much. No further questions.
No, sir.
To this day, do you even know what the letters ever said?
No, sir.
At the time, did you know what the letter said?
Not to my recollection.
Did you share with anybody what the letter said?
No, sir.
As far as you know, any communication that Mr. Brown had with his attorneys in that letter was preserved between those 2 folks, right?
Correct.
Did you ever hear anybody else talk about that they knew what was inside those letters?
Not to my recollection.
And certainly if you never saw what's in the letter, you never shared it, never heard anybody else talk about it, you certainly don't have any information whatsoever that the investigators in this case were ever apprised of what's in those letters.
Not to my recollection.
Based on what you know, do you have any reason to believe that anybody from the investigative team ever learned about what was inside that letter?
From myself speaking, no, coming from the age, I wouldn't have heard anything.
Besides you, sir, do you feel like anybody else ever looked inside those letters?
After I would have put that sticky note on them, I would have put them into the mailbox for her to pick up on her next shift, and other than that, I don't know what would happen with them.
And so at the time, contemporaneous with the time that you opened it up, you afterwards wrote that sticky note, right?
Correct.
And that sticky note says that there was 2 envelopes, right?
It appears obvious.
And the sticky note also says you weren't able to determine originally who the letters belonged to, right?
Correct.
And do you believe that, based on the fact that you couldn't determine who the letters belonged to originally, that you opened one letter, did not see Mr. Brown's name or the identity of the person who wrote the letter, and then opened a second one, same problem, and then you stopped?
That would be my safe assumption of what happened. Not fully remembering exactly the whole details of it. That would sound about correct.
And so you don't open letter 3, letter 4, letter 5, is that right?
Correct.
First of all, I also want to thank you for your service. You said 14 years you worked as a detention officer?
Shortly, a little over 14 years.
Certainly you believe that you can open a letter, scan it for a name of who may own it and may have drafted it at the top, the bottom, without looking at the contents, right?
I would believe myself to be able to do so.
You said earlier that you have a certain type of a value or principle where you don't want defendants to be talking to you about their conversations with their attorney, right?
Correct. My position out there was always, I'm there to house and make safe everybody in there. I'm not a lawyer or a judge or anything like that. My job was specifically for safety and security.
And part of your job is to log in the mail, right?
Correct.
And you can only do so if people follow procedure, right? And put their name on it and their CF number, is that right?
Correct.
If the name was on there, Sterling Brown had followed the procedures, or the attorney had properly addressed the envelope so the return address was from Sterling Brown, would you have any reason to ever open those letters?
Absolutely not.
This is the most important question. I asked it earlier, but I want to ask it again. I want you to take your time to think about it. Did you ever read those letters?
No, sir. I in full honesty, I can tell you I did not read any letters.
And additionally, if you didn't read it, you never shared the contents with anybody. Is that right?
Correct.
Nothing further. Thank you.
As you sit here now, just to be clear, you don't know how many letters you opened, 1 versus 2, correct?
I couldn't honestly tell you exactly how many. I obviously wrote that I opened up 2 at the time, but later in my interview, which was several months later, I believed that I had opened 1.
And if Agent Tucker's report has a reference in there to Captain Riley, your boss at the time?
Captain Riley.
Riley, I'm sorry, yeah. Talking to you afterwards and sort of reminding you or instructing you to err on the side of caution, would you have any reason to disagree with that?
I'm going to object. This practice of talking about what other witnesses said or what other witnesses said during an interview, I think is objectionable. What we need to know and what the court needs to know is what this witness has firsthand knowledge of, not opposed to what somebody else said at a different time. And I know it's an evidentiary hearing, and I normally wouldn't object, but it's being repeated, is what other people said, and asking a witness in a leading fashion to acquiesce to that.
Well, I think part of that is, as I've said, it will give 2 days, and the pace we're going, we're going to be a month. So I understand the objection. Obviously, I understand what the objection is, and that the best evidence is the actual witness that says the actual words. But I'm going to allow it in an effort to make this as expedient as possible.
There's other ways to make it go faster too, Your Honor.
Well, you already made your motion to dismiss tonight. Go ahead.
You understand my question?
Can we try that one?
Absolutely, yeah. If there's some evidence
that your boss had come talk to you afterwards and instructed you to be more cautious with legal mail. Would you have any reason to disagree with that?
I would have expected a probable correctable action from a supervisor.
You would have expected a reprimand of some kind under these circumstances.
At least a speaking to.
And do you have any idea what your captain may have done after that?
I don't remember.
No further questions, Judge.
Any personal?
Can you see me okay?
Yeah.
Yes?
Yes.
Good afternoon.
Afternoon.
Can you tell the court a little bit about your background and I just mean kind of key employment since high school and then where you work currently?
I graduated high school at Fergus High School in Lewistown, Montana. I went to Dawson Community College in Glendive, Montana. Upon graduation from there, I became employed at the Dawson County Correctional Facility in June of 2015. I've been at the DCCF since then for 10 years now.
Well, what's your rank?
I'm currently staff sergeant.
What other positions did you hold?
I started out as a correctional officer, promoted to corporal, then promoted to sergeant, and just recently promoted to staff sergeant.
If we go back to the 2023 timeframe between, say, January and August or September, what was your position at the time at DCCF?
I was a sergeant.
Can you tell the court what were you trained about when it came to protecting attorney-client communications for inmates? And in particular, I'm talking about when it comes to monitoring phone calls.
So, attorney phone calls, those, usually you can't have access to them at all. They will show a little recording, not recording, I don't know what the icon is, but you can't even click on it to listen at all.
Just speaking generally about listening to inmate phone calls, how often do you do that?
Since I've been in this position, I don't think I've listened to any phone calls.
In your position at the time back in 2023, how often were you listening to phone calls then?
Probably about every day.
And I understand you were one of the few officers who listened to a lot of phone calls. Is that fair to say?
Fair to say, yes.
And you listened both to recorded calls and you'd also listen to live calls, correct?
Correct.
And when you listen to live calls, and again, my questions are all back in this 2023 timeframe, but
Okay.
when you listen to live calls, would other officers also be able to hear?
I think so.
Is it played on a speaker or something like that? Is that how it works, or headphones, or what?
Yes, it can be played on a speaker, or you can listen with headphones.
And how would you typically do it?
I would say mostly just on the speakers. Depending if I felt like it was gonna be stuff that people did not need to hear, then I would use the headphones.
And back in 2023, when Mr. Brown was an inmate at your facility, you understood that he was charged with a serious felony. Is that fair?
Yes,
And in fact, that's one of the reasons why you were listening to his phone calls, correct?
correct.
You listened to his phone calls and you also listened to his co-defendant's phone calls, Jake Burkup. Is that fair?
Yes.
Have you ever seen the report from Agent Tucker
or the state's exhibit identifying the number of telephone calls that you listened to between Sterling Brown and his attorney?
I have a list of calls I listened to. I don't know if they're just with his attorney.
Okay. How many calls did you listen to? My total I have here, in case it helps, is that you listened to 10 calls between Sterling Brown and his attorney.
I couldn't tell you. I'm trying to open my thing and I can't get it open.
Let me know if you're able to get it pulled up. It's hard with Zoom, so I can't tell if you're ready.
Okay, I can still hear you. Just let me get my hotspot back on.
No problem.
This week. The monster.
Okay, I have it up.
How many calls did you listen to?
It shows 10.
And do you have the dates of those calls as well in front of you?
Yes.
Okay, we have Exhibit K, which I know you can't see, officer, but it's showing, again, for demonstrative purposes, that you listened to calls on February 15th, 2023, February 27th, April 3rd, June 13th, August 9th, August 11th, August 24th, August 25th, August 25th, and August 25th. Is that consistent with your list?
The last one is August 28th.
I'm sorry, you're correct and I'm wrong. I need better glasses. Thank you for correcting me. So a total of 10 calls.
Yes.
And it also shows you the percentage of time that you listen to of each of those calls. Is that also in the information you have?
Yes.
And so I'm just going to go, just as an example, on February 15th, 2023, you listened to 73% of the call.
Yes.
And how long was that call that you listened to in total? And I know that's a confusing question. Let me restate.
6 minutes and 30.
Go ahead.
6 minutes and 36 seconds.
Okay. So to do the math, then we just take 73% of 6 minutes and 36 seconds, and you can figure out the amount of the call you listened to, correct?
Correct.
Okay. And that would be, if my math's correct, 4 minutes and 49 seconds for that call. Okay.
Okay.
And then if I total up all the calls and do that for all the dates we listed there, I have that down that you listened to a total of 29 minutes and 7 seconds of these particular calls. Any reason to disagree with that?
No.
During one of the calls, you remember someone identifying themselves as an attorney, correct?
Correct.
And you don't remember which call it was or how long that call was, but you do remember someone on the line saying, "I am an attorney."
Yes.
And you remember the person saying,
this is an attorney-client privilege phone call or something along those lines.
Yes.
And so you were aware that that was a call between Sterling Brown and his attorney, right?
I wouldn't say I knew for sure that was his attorney.
After hearing that message, did you stop listening to the call?
I don't believe so.
Your belief is that you kept listening despite someone saying, I'm an attorney, this is an attorney-client privilege phone call, correct?
Correct.
And I heard you just a second ago where you said, I didn't know it was an attorney-client phone call, so I want to ask you about that because what you said is that in your defense, anybody could say they're somebody's attorney to deter us from listening to the phone call, correct?
Correct.
So let me ask you a couple points there. So first, that's never actually happened before to your knowledge, right? You've never actually come across a situation.
Not to my knowledge, no.
You've never come across a situation where somebody was trying to fake being an attorney, correct?
On phone calls, no.
Do you have any reason to dispute that the person who made that phone call, knowing what you know now, was in fact an attorney?
I mean, I guess I know now, yes.
Do you understand, at least now, that by listening to that phone call, that was a violation of the attorney-client privilege?
No.
If you were listening to a phone call and you heard that message, this is an attorney-client phone call, one of the options you had available to you was to pause the call, correct?
Correct.
And whether you're listening live or to a recorded call, you can pause both of them, right?
Correct.
And then once you've paused it, you have the ability to then check the number and see who it really is, correct?
I can, yes.
Have you ever done that before, where you had a call coming in and you weren't sure about it, so you paused it and checked just to be sure?
I don't believe I have.
Well, one of the options that you had, if you would have paused the call, you could have checked with the court, you could have checked with other officers, probably lots of different options to see whether or not it was truly an attorney on the phone. Is that fair to say?
Yep.
Before these calls that you listened to, these 10 calls we've identified here, to your knowledge, have you ever listened to an attorney-client phone call before?
No.
Have you ever listened to any since?
No.
Have you ever heard of an instance where another detention officer listened to 10 attorney-client telephone calls?
No.
So if my math's correct and you listened to about 29 minutes and 7 seconds of attorney-client phone calls, it's your testimony that you don't recall a single one of those conversations though. Is that right?
Correct.
So we can look at the list, and the first call on February 15th, you don't remember any of that call, or the second call, or the third call, and so on, right?
No, I do not.
And although you remember nothing about the calls, one of the things you're confident in though is you didn't share the information you don't remember with anyone. Is that fair?
Yeah.
We heard some testimony from Officer Nichols, the male officer at the facility. Are you familiar with her?
Yes.
And she testified that after the legal mail of Sterling Brown was opened. Well, are you aware that that happened? Are you aware that 2 of Mr. Brown's letters to his lawyer were opened?
I was only aware of one, I believe.
How did you learn about that?
I think just in briefing that morning, it was brought up.
So there was some discussion about the fact that his mail had been opened?
Yes.
Who did that briefing?
It was probably just us supervisors. I don't know who all was involved in the briefing. It's usually just like the sergeant and the corporal on day shift and the sergeant and the corporal on night shift.
And were you working days or nights at that point in time?
Days.
Can you say whether it was Rashton Miller?
That is my recollection.
So your best recollection is that Officer Miller gave a briefing to the other officers about the fact that these letters had been opened?
Or it might have been from Nichols.
And what was the gist of the briefing?
That there was a letter that I believe didn't have a name on it or something, and so they opened it, and the male officer was not happy about that.
Did she explain why she wasn't happy?
Yes, because I think it ended up being legal mail.
And did she explain that the mail was reported by the inmate to contain a narrative of events?
I don't know that detail now.
What you remember though is that she was very unhappy?
Yes,
And the teaching message there was what?
just err on the side of caution and don't open legal mail. Even though they weren't, I guess, 100% sure it was legal mail.
Did you ever report to a supervisor, an attorney, or anyone else the fact that you had listened to a phone call where someone represented that they were an attorney and that it was an attorney-client phone call?
I believe I questioned one of my administrators about it because I saw he had listened to it as well.
And what did that person say?
I don't recall.
If you were facing that situation today, and I appreciate that you're in a different job position now, but if you were still in a position where you were monitoring jail calls and you heard someone say this is an attorney-client privilege phone call, what would you do?
Probably do a little bit more background investigation.
No further questions. Thank you very much.
Thank you, Your Honor. Good, can you hear me okay?
Yeah.
So you talked about the legal mail situation. It sounds like you were not involved in that, is that correct?
No.
And you learned about it in a supervisor briefing? Is that correct?
Yes, I believe so. Yes.
And was there any discussion during that supervisor briefing or afterwards about what was contained in the envelopes that were opened, or was it just these were opened and that's a problem?
I think just that they were opened. I don't have any knowledge of what was inside.
Have you heard anyone talking about what was inside?
Not that I can recall, no.
So switching gears back to these jail calls, you testified that in your previous role as a sergeant, you would listen to jail calls daily, is that correct?
Yes, almost daily, yes.
Almost daily? Why would you listen to jail calls almost daily?
The safety and security of the facility. We've had a lot of drug issues and just people talking about stuff they shouldn't, so.
And so with that in mind, how did you select or choose which jail calls you were going to listen to?
I'd say like the bigger cases, like I said, on the county side, not that I had suspicion those guys were doing anything like drug wise, but I'd say the bigger cases on county side, and then the people that I suspected were conspiring about drugs on the state side usually.
And what was your process generally when you would be listening to jail calls? Were you focused on listening to the inmate call audio, or were you multitasking, or were you doing something else?
I was almost always multitasking. It was just background noise.
What were you listening for in the audio as you were working on other things?
Just any kind of words that might incriminate somebody or, you know, catch them more charges or anything.
So like if they're talking to someone they're not allowed to be talking to, things like that?
Yeah, yep.
When you're listening on a daily basis, did you focus in on a singular inmate, or were you listening to multiple different inmates' calls?
I usually listen to multiple.
And when you're listening to these calls, would you look specifically at the phone number they were calling and choose calls based on that, or were you just clicking through in the order they were recorded in?
Usually just clicking through.
What would you do generally if you heard anything of note?
I would make a note on the phone call as a bookmark.
So let's turn specifically to Sterling Brown when he was an inmate there at DCCF, okay? When you were listening to his calls, how did you decide which calls to listen to?
I think his were pretty random.
Who all do you remember him calling?
His wife, majority of the time, and his mom.
And you were asked already fairly extensively about calls with someone who may have said they were an attorney. Do you have, as you sit here today, any specific recollection about those conversations without telling us what that may be? Just do you have specific recollection of those calls?
Not at all.
Did you ever talk to anyone else about what you heard in those calls with the defendant and someone who may have said they were his attorney?
No.
Did you ever write down anything you may have heard during those calls with inmate Brown and someone who may have said they were his attorney?
No.
Have you communicated anything from those calls with any investigator involved in this case, either at the Prairie County Sheriff's Office or at the Division of Criminal Investigation?
I was interviewed by Brett Tucker.
And during that interview with him, with Agent Tucker, did you share any specific information from any of these calls?
No.
And just to be clear, have you ever talked to anyone about any information you may have heard during any of those calls?
Like I said, the only thing that I remember is him saying that he was the attorney, and I just asked my deputy warden about it since he had listened to it as well.
Staff Sergeant Patterson, did anyone ask you to listen to those calls specifically?
I don't believe so, no.
And is it correct, am I understanding your testimony correctly, that usually when an attorney call occurs between an inmate and their attorney, those calls are not recorded?
Correct.
And is it correct that you can't even access those?
Correct.
And is it correct that that occurs when an attorney verifies their phone number or an attorney's phone number is verified with Dawson County Correctional Facility administrators?
That's my understanding, yes.
And is it also true that an inmate could send a kite to have communication with their attorney set up?
Yes, I believe so.
And if such a kite was sent, would that communication or those calls with an attorney have occurred on an inmate phone or somewhere else?
Well, they send a kite requesting to talk to the attorney.
Yes.
They'll be set in a room with a phone that's not recorded.
And in this case, Staff Sergeant Patterson, as it relates to inmate Sterling Brown at Dawson County Correctional Facility, are you aware of any requests to have phone numbers associated with attorneys not recorded?
No, I had no part of that, no.
I have no further questions. Thank you for your time, Staff Sergeant Patterson. The defense might have some. Staff Sergeant Patterson, I'm sorry, I forgot to ask you one clarifying question. When we talked about you listening to these jail calls, where in the facility were you sitting when you would listen to those?
The sergeant's office.
Okay. Nothing further, Your Honor. Thank you.
Your statement that you gave, your transcribed statement to Agent Tucker, and I know you're not here, but you do recall giving a statement to him?
Yes.
And for the course reference, it's on page 3 of that statement where you were describing the fact that someone on the line said, "I'm an attorney, this is an attorney-client phone call." In order to hear that, you had to be listening to the words that were being said during the call, correct?
Correct.
And so while it may be background audio when you were monitoring calls, you were still listening, right?
Yeah.
Yeah, I mean, the goal, as you pointed out, was to hear for something incriminating or safety and security issues or maybe drug issues, right?
Right.
And you never heard any of those issues when it came to Mr. Brown, correct?
Correct.
And finally, when it comes to phone calls, first off, using the phone that you have to request permission to use, it's my understanding that there should be a log showing who uses that, correct?
Yes.
That's your understanding as well?
You're talking when they go to the room and have an attorney phone call?
Yes.
Yes.
And if that's the case, and if I represent to you that Mr. Brown used that phone, do you have any explanation for why there wouldn't be a record of him in the logbook?
No.
And in terms of becoming a verified attorney or logging in as an attorney, it's my understanding that now, since approximately November of 2023, there's a specific form for attorneys to fill out to log their number. Is that consistent with your understanding?
I am unsure of that.
And do you know whether or not there was any form back when Mr. Brown was an inmate at DCCF?
I do not know.
No further questions. Thank you.
Anything from the state? Area where others can walk by and listen. Can you describe the physical location for me?
Yes, it's an office that's located next to the break room. I almost always had the door shut because I was always cold and had the heater running. It wasn't locked unless I chose to lock it, but the majority of the time it was unlocked so people could come in and out freely.
Thank you.
You're welcome.
Lear, Stacylear.
I'm gonna make you much closer to the microphone. Okay,
How about this?
much better.
All right.
Okay, go ahead.
Good afternoon, Ms. Lear. We've met before, have we?
Yes.
Can you please state your current occupation for the court?
I'm a security consultant and I'm the managing partner for Halcyon Forensics.
What is Halcyon Forensics?
It's a digital forensics investigation firm based in Missoula, Montana.
Are you the owner of that firm?
I'm half owner of that firm.
Okay. Did you start that firm with your partner?
Yes, I did.
When did you start that firm?
In April of 2024.
Okay. And before you started that firm, what did you do for work?
I was a security consultant.
how long were you a security consultant, and can you describe that for the court?
Sure. I started working as a security consultant in the fall of 2023. I work for an international healthcare nonprofit with private clients across the United States and the globe. I provide physical security services, security resources, digital security, cybersecurity, intelligence, threat assessment, all related to domestic terrorism and extremism in the United States.
Okay, so you are smarter than I am. I'm going to, Your Honor, may I approach the witness?
You may, you have ongoing permission.
We're on M now?
Yes. And Michael.
Do you recognize Exhibit M?
I do.
How do you recognize it?
It's my resume.
Is it a true and accurate representation of your current resume?
It appears to be.
I move to admit Exhibit M into evidence.
State.
Thank you, Your Honor. The state objects. I think she's here before the court and can testify quite adequately in person as to her qualifications. I don't think it has any relevance.
If I have a resume, I don't have to write it all down. So there's no relevance to me. So I'll admit it. And Exhibit M is admitted. Really just to further inform the court record.
Thank you.
Thank you. Do you have any experience with working in law enforcement?
Yes, I do.
Can you describe that experience briefly?
Sure. I joined the Missoula Police Department in 2006. I served as a patrol officer until December of 2009, and then I was promoted to detective in January of 2010, and I was in that role for 10 years. I retired in 2020.
And what type of cases did you work?
Everything from shoplifting to homicide, so the entire gamut. As a detective, in my first 4 years, my focus was on fraud investigation, white-collar crime, complex embezzlement, things of that nature. And then starting around 2014, I began working more homicide cases and was assigned to major crimes for the last 5 years of my career and handled well over, I'd say, a dozen death investigations, most of which were homicides.
Did we retain you to review information in this case and to form opinions based on your review with respect to the attorney-client privilege issue?
Yes.
What did we ask you to do?
I was asked to review records, conduct tests, and then draw conclusions about violations of attorney-client privilege related to IC Solutions system records for the Dawson County Corrections Facility.
Okay. What is IC Solutions?
IC Solutions is a centralized inmate telephone calling system that is in widespread use at detention centers across the United States that has an interface for law enforcement to be able to monitor inmate calls.
Okay. Have you used it before?
I have used it a lot.
How many years, how would you describe your use of it? How extensive?
I started using it as a patrol officer so as far back, probably not in 2006, but soon after. So, and then after leaving the police department, I've also used it as a citizen to contact inmates. So I've used it on both sides.
Okay. Have you used it to monitor calls from a detention facility?
Absolutely, both the Missoula County Detention Facility and the Montana State Prison.
And what makes you uniquely qualified to testify about data from IC Solutions today?
Well, partly it's my actual use of it in investigations as a law enforcement employee monitoring inmate calls. But partly it's that my expertise is in the area of technology and telecommunications. So I'm a certified fraud examiner, so I have experience in auditing systems, doing internal investigations and misconduct. I'm also a subject matter expert in the use of criminal investigations combined with technology with telecommunications, specifically cellular technology. But phones work very similarly, it's just whether it's wired or wireless. I also hold the highest level of certification it's possible to have for the Cellbrite forensic tool. And I have an ITIL certification in Information Technology Infrastructure Library, which is best practices in IT. So I have a lot, and if you go all the way back to the start of my career, before I was a police officer, I was a data analyst at a Fortune 500 telecom company. And then from there, I became a paralegal, and from there into law enforcement. So my career path combines to make me, I think, the best option you have for telecom analysis.
Okay, I'm gonna have you slow down just a little bit this way.
Thank you, I can't get that a lot. I'm sorry.
Especially with the things you're saying. Did you form opinions and conclusions in this case?
Yes.
And before we talk about your opinions, what did you know before you did your own investigation about the issue of calls having been listened to?
You rephrase that question?
Did you know anything, did you review Agent Tucker's work done in the case before you did your own investigation?
Yes. So I was engaged to conduct this analysis in, I believe, August of last year. And I reviewed Tucker's report. I reviewed records from IC Solutions, an affidavit of Lance Jasper, and ultimately also some subpoena records from IC Solutions.
Did you in fact go to the facility as well?
I did.
Okay. When did you receive the subpoena return from IC Solutions?
The first time I saw that return was May 22nd when Tammy from your office emailed me and said it was available and sent me a Dropbox link. I was busy with other clients that day, didn't click the link, and then I right afterwards got a phone call saying, "Did you click that?" And I said no. And whoever I spoke with said, "Don't, it has audio from attorney-client privilege calls. Wait to hear from us." So I didn't do anything with the information. The next time I heard about it was June 4th. I went to your office and met with you, and you gave me a flash drive and said that it had the subpoena return documents on it, and that it did also have the audio. You weren't able to remove it, but that I should not look at or review or listen to those. So I received the subpoena return on June 4th in the afternoon.
Okay. And when did you finish your analysis and report of that material?
Friday, June 13th, close to 3 p.m. And that was pretty fast given that I just got the information.
Have you seen in your personal career as a member of law enforcement or working in a detention facility, have you personally encountered coming across a privileged call?
I have, one time.
And what did you do when that happened?
I was monitoring jail phone calls from an inmate in a homicide case. I heard the introduction to the call say Smith and Stevens. I immediately stopped the playback. I had a small panic attack. And then I called the county attorney, the defense attorney involved in the case, and the jail, and notified all of them that an attorney call was being recorded and that they needed to block the number. And as far as I know, it was blocked. It never happened again.
Okay. What, if anything, do you know about the underlying case?
So, Lance Jasper originally contacted me in July of 2024 and asked me to review data related to a vehicle extraction using the Burla tool in this case. And when he did that, he sent me a copy of a search warrant document that related to the extraction of the vehicle's module. I reviewed that search warrant. I have not read it since then, so what I recall is that it has to do, am I allowed to say what kind of crime it is?
Yeah.
Okay.
We all know.
We know.
I'm used to juries. So it was a homicide case and an arson case involving 2 defendants and across state lines. That's what I can recall.
Okay. Did you write a report in this case?
I did,
I think you said you finished it Friday night.
yes, afternoon.
Okay. Mark this as Exhibit N. You can take a few seconds to flip through it.
Ms. Lyons, do you have one more copy of the exhibits that we can give for the official copy of the record, or?
Yeah, we do.
I tend to write on mine and then I get in trouble.
Same.
Your Honor, if I may, while we're waiting, I would like to lodge an objection. I understand Your Honor is likely to overrule it. This is the report and associated data, some of the associated data and documents that were dumped on the state last night. So we would object on the basis of prejudice, unfair surprise, and also it's duplicative of the testimony we anticipate hearing.
Okay, and for the same reasons as we discussed earlier this morning, I'm still not happy about this. I'm not happy about the timing. But we need to get to the bottom of this. And I am confident that the state, while probably not sleeping tonight, will be ready to cross tomorrow. So
Okay.
I'm going to admit any over objection.
Thank you, Your Honor.
Can I confirm, Judge, that this is from the color?
For yours color, Jerry.
Okay, great.
And then, Ms. Lyons, are the other documents, are they going to be separate exhibits?
They're the same exhibits, Judge, they're just nicer looking ones of the ones that are in the report that are not color
Okay,
coded.
but otherwise it's all just exhibit N.
Yes. So Ms. Lear, can you just say your main opinions about the nature and extent of the attorney-client violations in this case based on your review of the material that you reviewed and analyzed?
Do you mean like a summary or my major opinions over like how?
Major opinions, and then we'll break them down.
So I'd say I have 4 major opinions. One is that the listen percentage is not an accurate representation of how much of the call was monitored. I can go into the reasons for that. The second is that the jail repeatedly failed to block attorney calls from being monitored over the course of more than a year. The third is that there is a conflict of interest in Agent Brad Tucker investigating his own investigation. And the fourth is just how extensive the monitoring was, how long it went on, how many people did it, how many people did it in spite of knowing they were attorney-client calls, and just repeated, constant, pervasive monitoring of attorney-client calls.
Okay, so I'd like to break those down a little bit. You said you reviewed Agent Tucker's report,
I did.
and I'm gonna hand you Exhibit O, which has been previously stipulated to. Have you seen this before?
Yes.
And I'd move for its admission, Judge.
Exhibit O is submitted.
You've seen this before, Ms. Lear?
Yeah, it's for the first time today.
And does this, well, what is this? Can you tell?
From what I see on this document, it says State's Exhibit 3, so I believe the state must have assembled this. It looks like a summary of the people or accounts who listen to calls with the percentage that they listen to. Two calls to 541-4100. And this must be a typo, 327-4100. Those are in red. I'm assuming they mean Lance Jasper's cell phone number, maybe?
I'll just represent to you that that is not Lance Jasper's cell phone number.
Okay, I don't know his number. I don't recognize that number, so I can't say what that is.
That's okay. But is the 541-4100, is that our office number?
Yes, it is.
The Reed Bell Jasper office number?
Correct, 406-541-4100 is that number.
Okay. And then there at the bottom of those three columns that have the number in red at the top, at the bottom it indicates that's a cell phone, correct?
That's what this document says.
Okay. And then if you flip to the next page, same chart, but just a summary of the time listened to. Is that what the document says?
That's what it says.
Okay. So you indicated earlier that one of your opinions was related to percentages of calls that were listened to.
Correct.
What is your understanding of how the percentages work and if they are a reliable way of telling how many minutes of calls were listened to and by whom?
So my opinion is that they are not accurate, and I believe Agent Tucker would agree with me, and he says this in his report early on, which is to say, for example, if you have a call that is 10 minutes long and someone listens to 1 minute of that call, it might show that only 10% of the call was listened to. However, in my testing at the DCCF on the live system, what I found was that it did not accurately show you which part of the call was listened to. So you can't say whether it's the beginning dial-up information where the inmate is stating their name and putting in their PIN number. You can't say whether it's the automated greeting that tells you that it's a call from a corrections facility. You can't say that it's the people speaking on the call or where in the call that it's being monitored. And I also found if you listen to a part of the call and then back out, go back in and listen to a second part of the call, as long as you don't exceed the maximum number of percent so far listened to, it won't tick that number up. So you could theoretically go 10 times into a 10-minute call and eventually hear the entire call listening to 1 minute at a time. It also doesn't accurately represent what happens when multiple accounts listen to that call. And I have no idea what it does when you monitor it using the live play system because I was not allowed to test that system. So if a person listens to any percentage of the call, I believe you have to assume that they may have heard all of the call. And even if they didn't, you can't know which crucial information in which part of the call they listened to. And for example, in Agent Tucker's report, it seems like he assumes that if you have a zero length call that doesn't matter because there's no length to the call. But in my experience, that is not true. That still includes the dialing portion where the inmate gets to say some things that are recorded. And I have personally found calls where inmates use that 10 seconds or whatever it is to pass information covertly because they don't think law enforcement listens to it. So I think you have to assume that if any call of any length was monitored, that a person may have heard everything on that call.
Okay. And so the minute or the hour and 56 minutes and 24 seconds that's indicated on the prior exhibit, that is like a very minimum.
Can I ask a question about this? Yeah, I would say yes. That is the minimum.
Okay. If there's something else you want to say about this, you're welcome to.
I don't, because I just saw this today, I don't know if this comes from the IC Solutions data, subpoena return. I suspect it doesn't because it includes listening percentages and that data wasn't provided in the subpoena return, which means this data is only current as of November 30th, 2023. So there's a lot more than this if this is based on that old data.
Yeah, and I'd like to talk about that later. You talked about
The listening continued after November 2023. There were additional attempts to access recorded phone calls after November 2023.
Yes, ma'am. Yes, sorry, yes, Your Honor. The records I received in the subpoena return from IC Solutions show that the last date that any call was marked listened to was June 4th, 2024.
Thank you. Excuse the interruption.
I'm going to go into some of the topics you addressed in your first opinion a little bit later. But was Agent Tucker able to identify listeners in his report?
Yes,
And you heard Taylor Patterson testify today. Were you in the room during her testimony?
I was.
What were your thoughts about her testimony, about her personally listening to calls?
I have 3 issues. Number 1 is that, yes, she only listened to 10 calls, but she listened to 1 call twice, so it's actually 11 listens to 10 calls. That's semantics. The second is that while she stated that the reason she was monitoring calls was for the safety and security of the facility, I heard her use the word incriminating, and it made it seem, my impression was that it was investigative in nature, not just about the facility. And the third has to do with listening to these calls. Actually, I have another concern. Listening to these calls in an office, in a common area, next to a break room where people go back and forth. In Agent Tucker's report, I believe it was Officer Miller also highlighted the fact that he would walk in and overhear people listening to jail phone calls on that speaker. And Lieutenant Conrad referenced that in my live testing. So there are 11 calls, not 10. Listening in a common area, listening for investigative purpose. And it's hard for me to believe that someone in law enforcement hears this is an attorney-client call and just decides to keep listening to it, and not just listen to it, but more than one time. So, for example, the February 15th call, the very first call that Brown made, shows Patterson listened to it 270%, which I'm guessing is not guessing, it says more than once. And that's the same call that later Sheriff Lewis says, I knew immediately it was an attorney-client call, and I stopped and I notified everyone. So if one person knows, how can Patterson not know? It just seemed blatant to me.
Do you recall how many listeners, or accounts Agent Tucker identified that had listened to calls?
He identified 12 accounts. However, at least one of those accounts was a shared account between multiple people with a minimum of 2 people using the account, a Perry County account.
And Ms. Patterson, Taylor Patterson, indicated that sometimes individuals would be in a room listening to the calls together on the speaker. That's obviously not captured on the IC Solutions data, is it?
Correct. I didn't hear her say together, but listening to them in a common area, yes. And Agent Tucker's report also has other instances of that. But yes, there would be no way to know who might be present or walking through or in the sergeant's office when an attorney-client call is being played on a speaker in a public area.
Okay. You next opined that the jail that personnel did not take measures to block calls or otherwise indicate that they were privileged. What suggests to you that that is the case?
There are numerous times when someone identifies a number or a call as being attorney-client privileged and tells everyone, even multiple notes made in the system related to a phone number or a particular call, and yet the records show that they continued to click on those calls and listen to them, right up to and during Agent Tucker's investigation. The subpoena response from IC Solutions includes a call that Prairie County account listened to on the afternoon of November 24th, 2023, which is immediately following the interview with Agent Tucker. And then Lance's cell phone number is not marked privileged until December 5th, 2023. And we know that they knew on February 15th, 2023, that at least the office number was a privileged call because Sheriff Lewis told everyone. So there are notes, and then there's continued monitoring. And that shows me that they weren't taking any efforts to block these calls. And in fact, we don't have any record that they blocked anything until December 5th, when I can only tell you that Mr. Jasper's cell phone number was blocked. I still don't know when the office number was blocked. And during my live testing in January of this year, Jordan Kilby's phone number, which I saw an email was given to Mike Gee, was still not blocked as I was testing the system, although there were no calls to her number from any inmate that I could see.
Okay. And I'd like to talk about the user notes that figured into that opinion a little bit later, but is it easy to block the calls?
Yes.
How do you block calls?
During live testing, I saw there were 4 steps. You look up the number, you click Edit Features, you click the checkbox that says Privileged, Do Not Record, and you click Save. And doesn't require special privileges to do that. Anyone corporal or higher can do that.
Okay, and so when you say it doesn't require special privileges, can you explain what that means? Are there levels of privileges or access in the IC Solutions system?
Yes. So just like with a computer, you might have multiple accounts to access a computer, and different accounts can do different things. The highest level would be a system administrator at IC Solutions, the people who own and maintain the system. And then the lowest level would be someone maybe with only read access, so they can't delete or change or edit or add. They can only see. That would probably be the lowest level. IC Solutions did not provide data that would explain all the different levels in their subpoena requests, so I can't say for certain.
Okay. Do you know, based on your testing of the system, who blocked the numbers eventually from the Reed Bell Jasper office and Lance's cell phone and Jordan Kilby's cell phone number?
The only one that was blocked was Mr. Jasper's cell phone number, the 370-3431 number. That was blocked by Captain Riley on December 5th, 2023. I don't know when the others were blocked, or Jordan's number was never blocked, or wasn't as of January.
Okay. Do you know if the system allows calls to be blocked retroactively?
Yes.
Can you explain what that means?
Based on my review of the manual for IC Solutions for facilities, that can only be done pursuant to a court order.
And do you know what level of privilege you have to do in order to do that pursuant to the court order?
I don't know.
Okay. You opined that it was inappropriate for Agent Tucker to conduct the investigation into this issue. Can you explain why that is?
In order for someone to investigate this kind of misconduct, the investigation needs to be independent and impartial. And in this case, it appears that someone asked, I don't know who, Agent Tucker, to investigate himself and whether he obtained information he should not have from agents of the state, law enforcement, jail staff, who he had directed to monitor calls. That just is improper. I don't know how he could be impartial. And when I reviewed his report, he doesn't appear to be impartial. Specifically, on the very last page of his report, he asserts very confidently that, and I think he says the word confident, like, I am sure there's nothing in my investigation that came from monitoring these jail calls. And I don't know how he can know that when he doesn't know what's in the calls, because everyone he interviewed says they can't remember. And they all talk to each other. And Dawson County has a population of less than 9,000 people. And in addition to that, so many different agencies are listening to these calls. You have the jail, DCCF, you have the Probation and Parole Office, you have the DCI Narcotics Bureau, you have Dawson County Sheriff's Office, and you have the Prairie County Sheriff's Office. And some of these people are doing this on speakers in common spaces. So do I think that he went out and gathered information on purpose this way? But I doubt it. But could information have made it to him that was tainted and he might not even know? I think absolutely. I don't know how you know. And then there are other instances in his report where it appears impartial, specifically related to the listen percentages. So as I think I mentioned, in his very first interview, which was with Sheriff Lewis, he conducted testing and discovered that the listen percentage was inaccurate, the same findings that I confirmed. But he continues to reference those percentages in a 44-page report 48 times, every time they're less than 100%. And the implication is it was a zero-length call, or they listened to 1% of a call, so it doesn't matter. But in cases where the calls were listened to at or over 100%, he only mentions that one time, even though there are at least 30 calls like that, and one of them is 556%. I don't know if he knows he's doing this, but what it appears is that he's giving and presenting a lot more weight to partially listened calls than he is to calls that were listened to at or over 100%. And then lastly, he keeps asking the attorney to disclose attorney-client privileged information in the case, and is asking everyone who listened to these calls to disclose that. It feels improper that if he did get something from that, now your investigation is tainted.
And it feels improper based on your experience as an investigator.
You just can't, not just an investigator, also my training as a fraud examiner. You can't investigate your own misconduct. It's just not possible to do it in an impartial, neutral way.
Okay. When you were an investigator or a detective, and when you were listening to jail calls, if you heard something about a case, would you share it with others or with the prosecuting attorneys in the case?
Absolutely, that happened quite frequently.
What's the purpose of doing that?
We're all in this together. When you're in law enforcement, you're constantly interacting with people who are interacting with people on cases that you are interested in or investigating. A detective would be listening to the calls, federal officers, drug task force officers, prosecutors. Basically, a lot of people have their hands in the jail phone call system. And it is common for us to hear something we weren't even looking for and then call someone else up. I can think of so many examples. You would just find out who the investigator was, call them and say, hey, you should listen to this jail phone call that I just listened to. Or here's what I just heard I ended up testifying in a case related to this. The jail is a part of that too. They're monitoring calls. If they hear something, they'll contact you and let you know that you should be paying attention.
Okay.
At least that's how it was with Montana State Prison and Missoula County.
I want to talk about your visit to the detention center. Did you learn anything from your tests that you did there that was new information, not discovered or otherwise articulated by Agent Tucker in his report?
Yes.
What did you discover?
Most notably, one call, I believe it was from March, maybe March 8th, 2023. It had a note on it from Captain Riley that said regarding legal mail. That call had been downloaded and the live system showed that. There's nothing in the IC Solutions data that talks about calls that have been downloaded, but they have a different designation than if they're played or listened to. So that means a person physically downloaded the file to a local computer. And then once that occurs, there's no record of what happens to it after that. If it's copied or played or listened to or notes are added to it, you've downloaded it, you've taken it home with you. I don't recall seeing anything in Agent Tucker's report about downloads, and I think that's very important. And then the second thing is just the full extent of how many calls were monitored. When he was doing his investigation, he only had access to the data that had been provided as of November 30th. By the time I'm there, 2 more months have passed and there are a lot more calls that have been monitored, which is then confirmed with the subpoena response 2 weeks ago.
What exhibit are we on? Pete?
Yes.
Handing you what's been marked as exhibit
I sure would, Your Honor. Thank you. The state was just handed this proposed exhibit P, I believe we're on. I am estimating, this is lawyer math, but it looks to me like it's between 3/4, I would say a half to 3/4 of an inch thick of Excel-like data lines. The state believes it first received this document, which is not page numbered all the way through, but the last page number I see is over 100 last night at 5 p.m. So we would object on the basis of prejudice and unfair surprise and anticipate the court's complaint.
Thank you. Briefly, Judge.
Tell me why I need the underlying data. Obviously, it is what the expert's opinion is based on, but she's already provided summary information regarding the number of calls, her concerns regarding how the listing of the calls and the percentage of calls was calculated, her overall criticisms of Agent Tucker's report. Why do we need the data?
One of the tabs in there, Judge, contains user notes, which is what the jail staff wrote in response to their listens to the calls. Additionally, it's just easier for her to reference, for instance, specific numbers that had listened to calls.
Is that this page?
Yeah. It was bad. Yes.
Okay. So why do I need the other 250 pages of the exhibit if all we're going to talk about? I
Mostly.
assume you're trying to show me that folks understood that these were attorney-client or attorney-related phone calls in these notes. So that's the point of the notes.
That, and it helps Ms. Lear explain her tests that she conducted and what information she was able to glean from those tests, and also just in the interest of completeness and having the entire record that was produced. And then furthermore, we sent this to the state on June 11th, so they've had it for not much more time, but more time than
4 days before the hearing. So here's the problem is, I think Ms. Paddock's going to do a great job of cross-examination tomorrow, but it's one thing to get a 31-page report. It's another thing to get 150, 200 pages of raw data and then expect an attorney without an expert sitting next to her explaining it to be able to be prepared. So
if you're inclined to refuse it, Judge, I would make an offer of proof with this exhibit, but I would ask you to admit the third tab, which is the user notes, at a very minimum.
what I'm going to do at this point is I'm going to give the state a lot of latitude. And when we're done with this hearing tomorrow, if the state wishes to have this report and the transcript of Ms. Lear's testimony reviewed by an expert, I will leave the hearing open and we will reopen if it's necessary, because the plot is thickening by the data that's now being put in front of the court and being put in front of the state. And there's really no other way to describe it as total ambush, but we gotta get through it. So, what we're gonna do for today is I will admit it, but I do want to make sure that everybody is aware that if at the end of the day tomorrow the state says to me, we need to be able to address some of these issues, I'm gonna give them that leeway. Okay?
Okay, Judge.
Okay, so for now then, we are admitting this giant sack of paper as P as in Paul.
Thank you.
Yes.
Did you, when you were at the detention center, did you reproduce the test that Agent Tucker did on the jail calls?
Not all of them because of the limitations, but some of them I did, yes.
And when you went to the detention center, who was there?
Myself, Lance Jasper, Lance's assistant, Scott Kinney, it's Kinney. Prairie County Attorney Dan Rice, and Special Deputy Prairie County Attorney, I don't know if I said that right, Dan Gazinski, and Lieutenant Joshua Conrad from the DCCF.
Okay. And when you were doing your testing, did Mr. Kaczynski say anything to you about the scope of your testing?
I'm not sure I understand the question.
Were there any limitations on the testing you were able to do?
Yes.
Can you describe what the limitations were and who imposed those limitations?
So there were 4. I would say the first limitation is imposed by the way the testing was set up, which is to say I was not given my own account and unlimited time to do testing remotely. I had to be there. I was told that Lieutenant Conrad would be moving the mouse and keyboard, that I couldn't touch anything. I could only tell him what to do. I couldn't ask any questions. The issue with that is that almost immediately, I learned he did not have the highest level of privilege on that system. He said he did, but then walked it back and said, actually, I don't, Portland Tom Green does. And then I asked to see that account and he refused to show it to me. And then said, I actually don't know how many privileges I have on the system. And that happened because the very first test I tried to do was to pull up all the calls to your office number, and his account could not do it. It wasn't allowed. So that considerably narrows the scope of what my testing could do, because now I'm limited by this person's administrative privileges. That was the first one. The second one is that I was not allowed to test the live play system. In Agent Tucker's report, he often references calls that are listened to through live play. This is a real-time monitoring of in-progress inmate calls. I know the probation office listened to some, others as well. The highest percentage of calls listened to was by the probation admin assistant, Charlene Green, 556%, and that was done on a live play system. So I need to test that to find out, how do you get over 100%? And Lieutenant Conrad told me I would not be allowed to do that. He initially said that it couldn't be done outside the facility, but I feel certain that it can, because that was done by probation and parole, DCI narcotics, like other agencies. So it can be done outside the system, and he just wouldn't allow me to do it. So I was not able to do any of that testing.
Were you able to review data related to Jake Burktiff's calls?
No. There are more limitations, but I can stop there if you like.
Yeah, what other limitations were there on your testing?
2 more, I'll be brief. One is that Lieutenant Conrad was only available until 2 p.m., which I didn't know at the outset, and which required me to significantly shorten my testing. His wife had apparently been in the hospital and he needed to go, and at lunch time, Mr. Kaczynski said, we gotta be out of here by 2. And expressed that he didn't even understand what possible more tests I could have to do in the amount of time left. And then the last one is that the IC Solutions subpoena response was completely incomplete. So my testing is partly relying on the fact that later I'll be able to compare what I've done to business side records, and then those records were not produced.
Okay. Is the packet of material that we just admitted as an exhibit, was that what you reviewed from the IC Solutions subpoena response?
Yes.
Do you have concerns about users of the system deleting things, or do you believe that this is possible?
Yes, on both counts.
Why do you believe this is possible?
Because again, I didn't have access to the highest level of administrative privilege. A person with the highest privilege should have the ability to edit and delete data. However, an audit trail would show that that had occurred, and that's some of what I was looking for in my testing and from the business records in the subpoena. But IC Solutions did not provide that data.
Did you, you reference audit logs in your report?
Yes,
What is an audit log and is it important?
it's critical to authenticating data. An audit log is like a breadcrumb trail of who did what and when on a system, so that if someone does go and delete something or edit a note on a call, you can see that they did that and when they did it, and often you can even see what change occurred. But again, that data was not provided. So I have no way to say that these records have not been altered in some way.
Do you know what level of clearance or access privileges Agent Tucker was given?
I do not.
Do you know if there were any limitations on the time that Agent Tucker had to complete his investigation and report?
I don't know if he was externally limited, but his investigation spans from November 15th, 2023 to at least December 21st, so about 5 to 6 weeks.
If you had an unlimited amount of time at the facility, or even any more appreciable amount of time, what other testing would you have done, and what would that testing have revealed?
There are a lot more tests that I would do. I think I described about 2 pages of them. But the most important ones would be those audit logs. I did not get to see, except for that one call, anything having to do with downloaded calls, and that's obviously vitally important. And I was not able to see anything having to do with deletion or edits. I would also want to do more testing on creating privilege numbers and testing privilege, whether it's recording, whether it retroactively deletes, what it shows when someone accesses those calls, things of that nature.
Can you tell us, my understanding is that there's several components of this packet of data that you reviewed, and they can be broken down into 4 components.
Yes.
What are the different files that are tabbed in that exhibit?
So these are the files we received, or I received, in response to the subpoena from IC Solutions. The first giant one, that's 102 pages, is every single call by Sterling Brown that was monitored, whether it's an attorney call or not.
Okay, what's the second tab?
The second one is only those calls by Sterling Brown that were to 406-541-40-100, which is the office number for Mr. Jasper.
Okay, what's the third tab?
The third is the user notes. So this is any note that anyone with an account added to Sterling Brown's calls, whether or not they're attorney calls.
Okay, and what's the final?
There's actually 2 more.
What's the 4th one?
The 4th one is the global number edit page for Lance Jasper's cell phone number, 370-3431. This is the only document that shows when that call was that number was finally blocked and who did it and when.
And then what's the final?
And As best I can tell, this document was provided by mistake. These appear to be call logs or calls by an inmate with the last name of Young. And his inmate ID is very similar to Mr. Brown's inmate ID. So I haven't really reviewed this because it's not relevant. There are no attorney numbers in here. I don't know what this has to do with the subpoena or the investigation.
Your Honor, if I can jump in there before we move forward with that, based on that information, I'm going to move to strike that fifth tab of this exhibit.
I'm fine with that as well, Judge.
So the fifth tab, exhibit P, will be removed. And that would be an Excel spreadsheet where their last name states Young. And there's no objection from the defense.
Thank you.
On the first tab of information, the Brown all recording access, what was the takeaway for your investigation from this tab?
What I said, it's actually 103 pages of every call that Brown made, regardless of who it was to, that was monitored. So it's a lot of information. It does not contain a listen percentage. And that's all I can say about that document.
Okay. The second tab, you said it shows every call by Sterling Brown to the Reedville Jasper office number that was monitored.
Yes, I should also add that it also includes video calls. And the name of this document is something to, excuse me a moment. This is supposed to be all monitored calls to 4100, but it includes these video calls. So I don't know if those calls were also to Lance Jasper or not. So because I could not tell, I excluded those from any analysis or numbers that I did.
Okay. Did IC Solutions provide a file for Lance's cell phone number?
They did not.
Do you think that that would be important to get the full picture of the monitored attorney-client calls?
Yes.
From your review of this tab, can you tell how many calls total with our office were listened to and how many times they were listened to?
For the 541-4100 number, 70 unique calls were monitored a total of 90 times.
And how many different user accounts?
I don't know that I differentiated them from the overall data, so I don't want to say. I'm not sure.
Did you attach a chart to your report that illustrates the amount of calls?
I did.
Can you explain that chart?
There are two charts. The first is called Heat Map of Jail Monitoring. So on the left side, you see the CSN, that's the call serial number for each individual call that Sterling Brown made to an attorney number. On the bottom, you see the account name for the user that listened to one of those attorney-client calls. On the right side, you see a gradient list that shows how many times each person listened to one of those attorney-client calls from those accounts. And then the numbers in the center are how many times for which call. So this just gives you an idea of who listened to the calls, how many times, and which calls.
And so then the other color printed chart, total jail call listens by user account.
Yes. And that's exactly what it says. It shows how many calls were listened to that were attorney-client privileged and by which account.
Okay. And so we see the most listened to call. Can you explain the Desi Riley column and why there's two? Do you know?
I don't know from anything I've heard here today. It appears to be two accounts with the same last name and same first initial maybe, There's Desi Riley and there's Dee Riley.
Okay, and almost 70 listens on one call, or can you explain what that means?
That's 70 listens total, so that would be multiple calls.
Okay, thank you. Do you know who uses the Prairie County account based on anything you've reviewed from Agent Tucker or your review of the system?
I do. At a minimum, it's at least 2 people, Sheriff Lewis and Deputy Gray Eagle. I don't know if it's more. It's clearly a shared account.
Okay. And moving to the next tab in the IC Solutions information. I believe this one is called User Notes Brown.
Okay.
When you reviewed this, did it cause you any concern with respect to the issue of the attorney-client privilege violations?
Yes. Specifically, it's clear that they knew these were attorney-client privilege calls in some cases. And secondly, some of these look investigative to me. They don't look, maybe they're safety and security, someone would have to explain that, but when I look at it, there's comments that don't seem to relate to the safety and security of the facility on here.
And then you said there were some that indicated that they knew that they were attorney-client calls. For instance, midway down on the second page, Desi Riley indicates Sterling Brown's attorney cell.
That's correct.
Are there others like that?
There is a call on the 3rd page for March 9th, 2023, where Desi Riley adds a note to 541-4100 that says regarding legal mail, and that is your office number. There's another one on that same page by the Prairie County account on March 8th, 2023, again to 541-4100. And the Prairie County account had a remark that said, clicked on this by mistake and did not listen to the first couple seconds until I heard the name Tammy and did not recognize it as a familiar name for Sterling normal calls.
Okay, and then back to the second page, the second one down, second entry down, Desi Riley says, talking about possible plea deal for him and about bird diff.
Correct. That's not to an attorney number, but that's one of the kinds of notes I'm talking about.
Okay. So evidently, the users were listening to the content of the calls.
Yes, the users who added these notes. Okay, let me clarify. Assuming that the content of the calls matches the notes here, then yes. I haven't listened to the calls.
Okay, and then the next tab in that documentation, why is this document important?
Can you reorient me?
So after the user notes tab,
Wouldn't that be the young data that was excluded?
I know the one before that says the enforcer at the top.
Yes. So this is the global number edit record associated with Lance Jasper's cell phone number. And can you ask the question again?
Why is it important to your analysis?
Similarly, it contains 3 notes, all by the Desi Riley account. The first one is on August 11th, 2023, that says Sterling Brown's attorney cell. This is the same one that's referenced on the other document, but this is attached to the cell phone number. And then what this record shows is that obviously this account knew this was an attorney cell phone back in August 2023. But this document shows that it was not marked as an attorney privileged, not recorded number until December 5th, 2023.
Okay.
And there's a second note actually on December 1st that also says it's an attorney cell, and it still wasn't blocked until the 5th.
Okay. Based on your experience and your review of the IC Solutions material and Agent Tucker's report and listening to all of the testimony today, how would you characterize the nature of the attorney-client violations that occurred in this case?
It is systemic and egregious, in my opinion.
Did you find it problematic that there are recorded audio calls with an attorney and client at all?
Yes.
Does the fact that the attorney-client calls have not been retroactively blocked mean anything to you today?
Yes. The subpoena response only covers a certain period of time, and I had unexpected results, namely that there were calls that are marked listened as of June of last year. So that indicates, so I believe Brown was long out of the facility by then. The fact that they still have these recordings, they could still be listening to them, and we would have no way to know unless we went back to IC Solutions and got another set of records. That's my concern with the calls being recorded and still available on the system. And I know they're available because the audio was provided in the subpoena response. So IC Solutions at least still has them.
Okay. This other color printed chart that's in your report, did you create this chart?
The attorney-client privileged call monitoring summary, the red
Yes.
and white stripes.
Yep.
I created this.
What does this show?
So, as I mentioned, the subpoena response was incomplete. It didn't include listen percentages, and it didn't include the date that the original call was made for some of these. So what I had to do to produce this report was combine the November 30th, 2023 all calls and listen reports that we previously had and that Agent Tucker relied upon for his investigation, and then combine that with this giant all calls, then filter this for attorney numbers, and then I put it, the most simple way is I used a computer programming language to write a program that pulled out only the calls to attorneys that were monitored and added all data from all three sources using that call serial number as the common identifier. So that is how I created this. So this is a summary of attorney calls that were listened to, who listened to them, how many times, when, and what percentage if we have it. And then the user notes, I combine that as well.
And based on having done all of that analysis, what is your grand summary conclusion about the nature and extent of the attorney-client calls that were listened to?
That over the course of 476 days, 83 unique calls were listened to 127 times by at least 12 government accounts, one of which was shared, and many of which listened to those calls in common areas where others could have heard them and had it not been captured.
Thank you, Ms. Lear. I don't have any further questions at this time.
What exhibit are we on now?
Oh, nothing new exhibit.
I'll also just briefly in this line to make a record that I did review KK, which is the full board video. I did watch that during the break. I didn't have any questions about it. It's pretty short and sweet.
Okay.
So thank you.
Do you recognize exhibit KK?
I do.
LL. Sorry, LL.
I do.
Any objections?
No, no
Under
objection to
seal.
LL. If it's already been filed in this case, no objection.
Okay, so LL will be filed under seal given the nature of the document, which is that immunity provision.
And this court had set this hearing, October 4th, set an October 4th hearing on August 29th of 2024. Do you remember that?
That's correct.
And so, was it surprising to you to receive this filing in November of that year?
Yes, and that's why tying these two together, the parole hearing, and seeing the date of the parole hearing being after the court had set a hearing on our motions that were briefed.
You mean before the court set the hearing?
No. The court had set a hearing in August.
Yeah.
For October 4th.
Yeah.
And then to see a parole hearing take place in between that time period and the hearing, when it was still undecided whether immunity was deadline. That was trouble. But then to see this agreement on, and then looking at the parole agreement, which required the state to do certain obligations in paragraph 13 on it, and then in watching the parole hearing that took place where the state failed to live up to number 13. But what became obvious is there was some type of meeting that happened off of the record, and then to see that Mr. Burdoff's sentence had been amended without court permission was really troubling. It was very difficult for me to understand.
Okay. And do you feel that not knowing whether Jake would be testifying in Sterling's trial for that period of time has prejudiced his defense?
Well, absolutely. We're sitting here right now, a month before trial, or in August, not a month, but 2 months, August, on it. And given the fact that we were in October for sitting here, and 2 weeks prior to our October 4th hearing, they had went to the parole board and, unbeknownst to us, secured his release, secured what unknown amount of information from him on it, and have made some sort of a deal without informing the court, anyone, and then only turning it over to us after we filed a brief discovery.
Okay. And then just to wrap up, there was an exhibit that I forgot to admit during my discussion of all the jail visits. So I'm going to approach you with exhibit MM. Do you recognize this?
I do.
How do you recognize it?
This was the one time that the detention center asked to be provided information prior to a visit where I was taking one of my employees, Scott Kinney, so that they could do a background check in advance. And so this is what we provided them, and this is what the deputy warden. And so the importance of this to me is it shows, one, complying with any request that the detention center requested of us, but even more importantly is that this was not in the file of my client Sterling Brown. And any improved visitor or that type of information is always contained in the file of your client or the inmate file on it. And so to me, it just shows that things were removed from the file.
Okay, so I would move for the admission of this exhibit under seal by virtue of the fact that it has Scott's social security number and his driver's license on it.
No objection.
And is admitted under seal. That's fine.
Okay. And so did you think, based on the warden indicating that everything came back clear, we'll see you on Saturday and Sunday, that it was good to go?
Again, I had no idea what was going on with the recording and that type of stuff.
Okay. Even as late as August 16th of 2023.
Yeah.
Okay, and then last point that I need to cover is with respect to the IC Solutions user notes that have been testified about in trial. Was there anything that bears on the issue of the violations from your perspective and the prejudice to Sterling's defense?
Yes, if I can find out here what number is it? Let me, sorry. So if you review this, what you will see that...
I'm sorry, Mr. Jasper, can you tell me
Yes.
what this is?
Oh, sorry, Your Honor. If you look at the note section, this portion, Your Honor.
Okay, so the note section done by DCCF in the chart of phone calls listened to.
Yes, Your Honor. On it. There's going to be a reference section here and the ID's phone numbers. And then you're also going to see the type there that says like call record, bookmark, video visit, call playback on video visit. So if you go through all of those, Your Honor, what you'll see is basically all of the types of video type of where they could observe you are listed. However, the one that I pay most attention to is the one on page 3, which is the partial there. If you look at that top one, it says Des Riley, that one 39714. It says bookmark CSN 3193066. And it says Trent broke his jaw, not forced. That one, Your Honor. That one there doesn't have the type or a reference to anything that you would normally see on it. The only way that that information could have been obtained, in my opinion, is either through mail or through an attorney-client meeting. And the reason I say that, Your Honor, is I know the importance of that. And that information there absolutely could not have been obtained anywhere else. And the importance of that to me is the fact that it is contained and going to review all of these notes, and the fact there is a statement down here, you may want to listen to the entire call. Is assigned to the prosecution and investigating team that they're relying on these notes as well to further their investigation on it, combined with the previous information I talked to you about with the draft report.
And with the comment about the Trent broke his jaw, do you believe the same thing about the note before that on the prior page?
I don't know about that one. I can't speak to that one. I just know for certainty with the specific nature of the other one, I am confident in the fact that everything else identifies an area that is video call or video visit or this and that. The only other place that is mail or on a unique time of that event is at the time if that note was made, that was at the mail opening event. And regardless, it shows that the idea that they're not working with the prosecution, to me, doesn't seem possible.
Okay,
Thank you.
thank you. Does that call,
It's not a call, sorry. That entry. It is a call.
bookmark is made on March 9th, 2023 at 7:14 a.m. Is there a corresponding call that was identified as an attorney-client call around that time?
No.
Okay. Okay. All right, this line to be done?
Yes.
Okay, so, Steve?
Clear, Mr. Jasper, you're indicating that the note that you're looking at states what?
The note,
Specifically, what does it state?
the author states DESIRILLEY as author, created 3/09 of 2023, 07/14, type bookmark, CSN 3193066, says Trent broke his jaw, comma, not horse.
Who broke his jaw?
It says Trent broke his jaw, comma, not horse.
And just, I need to clarify the record. What Mr. Jasper has been referring to is that he is in Paul, tab 3, page 3 of tab 3. Just so that's clear. Go ahead.
Thank you. And you think that whoever did that note and got information about a person named Trent's jaw from communication that you wrote, or he wrote, or a phone call?
No, it was not a phone call. It would have either been through a meeting with me or through legal mail.
Who's Trent?
Refusing to answer that.
Okay, well, it seems to me, and tell me if you agree, that whatever happened to poor Trent and his jaw, that many other people may know about it, right?
I assume they do now.
Yes. And then other people may know about Trent's jaw that are familiar with Sterling Brown, correct?
I assume so now.
Yeah. And you would assume that perhaps family relations, friends of Trent may also converse with Sterling. I mean, the way you're making it sound like is the only person that knows about poor Trent's jaw is you and Mr. Sterling. Do you believe that's the case?
No, but based on this record, it would link to a phone call or it would link to another source. If you look at this closely, you will see that everything is linked to a phone call or a video visit on it. My point is that if you check that CSN number, it's not linked to anything. And so my point is that the only thing left that's possible is where I meet or meal, in my opinion.
Okay, so since there's not a citation of where that information came from, then it came from your communications with your client, is that right?
That's my opinion.
Okay. Okay, let's move on here a little bit. I'd like to talk, let's start with maybe a smaller issue, this Brady issue. on September 17th, there was a parole hearing, right? For Mr. Jake Burdup, right?
Yes,
And for the most part, parole hearings are public, right?
it should be.
And how many parole hearings have you been to, you think? I imagine a lot.
Quite a few.
And you know that currently parole hearings have a different protocol. They're mostly, I think, almost exclusively done by Zoom, right?
It's been a few years, but usually I do a buying always in person, especially on a homicide case.
I don't think they let you do that anymore. You know the chairman, I think his last name's Hurt, I think it's Steve maybe Hurt is the chairman.
I don't know.
I think he's with law enforcement here in Billings, no?
I don't know.
You don't really know what his practice is, right?
I do not.
But you would know that Chairman Hurd would, if he is indeed the chairman of the parole board, he runs the parole board, right?
If he is the chairman, then he would be in charge.
And you would agree that the parole board would have the safety and security of all parolees in mind when they act, right?
I don't know. On a homicide case, I would, generally, when I've been there, no.
So you don't know whether it was actually Chairman Hurd that wanted to close a certain portion of that hearing, right?
No, I wasn't informed that this was gonna take place.
It's a parole hearing, right? The calendaring of a parole hearing is public, right?
I was not informed, so I don't know.
Okay. So based on the video you just saw, the court just saw, you will see that Mr. Burdup is represented by a very well-known attorney, Greg Jackson, right?
Yeah, I know Mr. Jackson.
Of course you do. And then you'll see that the state is represented by myself and Ms. Paddock in that parole hearing, right?
Yes.
And you also know that Haley Priscilla and Mike Haas also had an enduring attorney-client relationship with Mr. Burdup, right?
Absolutely.
And so what you saw was Mr. Gazinski, Ms. Paddock, attending a parole hearing on a homicide case where we don't speak, right?
No, you say 2 words, that's all.
Yeah. And so would it surprise you that given the fact that what is happening here with the state entering into this contract with Mr. Burdup, where he may be released if he's cooperative with testifying at trial, are you surprised that Chairman Hood would not want to make Mr. Burdup a snitch as he returns back to his cell?
Yes, sir. Would it make?
Are you surprised that he wouldn't want to do that? That he wouldn't want to protect his physical security, knowing that he was entering into a contract with the state where he would testify against somebody else that was charged with homicide? Would that surprise you?
Objection calls for speculation.
Would you want Mr. Hurd to take into consideration the safety of inmates?
Yeah, I would.
The idea of Mr. Burdup entering into a contract with the state, do you think that's somehow improper?
Absolutely.
And the idea that it would be improper is because, only for really one reason, it's improper in your view because it means that Mr. Burdup will testify, right?
No.
Okay. Do you think I have the power to rule on the present motions about the immunity agreement?
No.
The judge does, right?
Correct.
But I can enter into an agreement, a contract, where I show up for the parole board and say to the parole board, we don't object. And this is what's going on with the agreement.
No.
And what's your legal basis for that? Like, what's your legal basis, yeah?
Legal basis?
Yeah.
You don't have the ability to contract with someone until you have a decision from the judge of whether or not you have the ability to do that.
Well, I don't think if you look at the affidavit and you look at everything, certainly the affidavit talks about if he's allowed to testify. You saw that language, if allowed to testify, right?
This, has two different parts to your agreement on it. One is use immunity and transactional on it. And you're talking about two different things. So with regards to transactional, potentially I would agree with you. But when it comes to use immunity in this agreement, absolutely not. And then secondly, is this would have required you to modify the sentence of Jake Murdoch to see that the conditions were changed as it occurred after 120 days after his sentencing. And because the Department of Corrections overrode his sentence and put him to Montana State Prison, which we know happened because he had to wait a quarter of the time before he was eligible for parole on it. Thereby, either you had to go through the sentencing judge or this court here, and knowing that it was both pending. It's similar to Rule 35 in the federal system.
No, I don't practice in the federal system, but let me cut you off. The idea that Ms. Paddock and I said, we want you to testify. We need your cooperation. We don't want to force you to testify. You know, when we compel somebody, when the court compels somebody, we want your cooperation. You think that simply saying, we're not going to object to your parole, we'll show up at the parole hearing, we won't object, we'll tell the chairman of the board what's going on, and we don't object. You think that we can't do that? The prosecutors can't offer up immunity with court's blessing eventually, if the court does allow it. You don't think we can do that?
Not in this circumstance.
Okay, well, the judge will make a determination on that. Let me ask you one last question. You have received a copy and discovery of Mr. Bergdorf's statement, right?
Bergdorf's statement?
Yeah, to Brad Tucker.
I don't believe so. After the
No, he was interviewed, you got a statement, right?
From initial statement, yes.
Right?
The initial statement, yes.
And you were present at Mr. Bergdorf's trial in Glendale, right?
Yes, I was.
Were you present when he testified?
The trial?
Yeah, when were you present during the whole trial?
I believe I was, yeah. Most of it, no, take that back. I don't think I stayed for all of it. Most of it, no.
Okay. Let me ask you this, why don't you want him to testify in this trial? Well, why are you not wanting him to testify?
Objection calls for attorney-client privilege, calls for work product privilege.
That's the one.
Tell the court this immunity, you were advised back in November of 2023, we have trial, November of 2024, we have trial in the late summer of 2025. Having knowledge that the state has received the cooperation of Mr. Bergdorf, do you believe you've been prejudiced?
Absolutely.
Okay. What were you prevented to do after November 2025 that you wanted to do?
It's not in November of 2025.
2024.
In November of 2024.
Yeah. What were you not allowed to do based on the knowledge that he was cooperating?
It's at this point in time, so right now, at this sitting point in time, we didn't know until November. So what do we? So from this point in time, October, all this point in time, we haven't been able to do anything in prep because we have no discovery. We haven't been able to do any discovery on it. Our whole trial strategy. We don't know what information that you obtained with regards to with Mr. Bergdorf on it. You sat on this immunity agreement for weeks, and it was only until we filed our Brady motion that you actually disclosed it to us on it. And so we have no idea what information you obtained from him at this point in time. We have no idea what you said behind closed doors, evidently, with the parole officers to obtain this. If we just go with what you said, that this is why the parole hearing was handed, it makes it seem like it was just out of the goodness of Mr. Bergdorf's heart that he decided to testify rather than whatever was said behind closed doors. I don't know if that was recorded or as a record on it or anything like that, like I said, I'm all about protecting the co-defendant here, but you self-created the safety issue for him because we were having a hearing on October 4th on it before this court on it. And so we come to the court and say, this is all about his safety. You created the mess. We were here and you knew we were having this hearing. And so what was the big rush? Because he's in the state prison safe. It's only when you make this immunity agreement is that he's actually in danger on it. Because prior to that, he's not. And so if this was settled with the court's approval and you got it, good deal. But it's only the fact that you create this issue is his, threatened here, and then his health and safety being at risk seems like an issue that would have been disclosed to his counsel. And to my knowledge, from talking to them, that was never even conveyed to him as an issue.
It was, so you don't know whether that issue was fully and completely discussed in front of Chairman Hurd?
No, it clearly wasn't because it was not on camera.
And you don't know what was discussed between Greg Jackson and I, do you?
No, that was all kept from me.
I'd like to change to the other issue here. You have indicated today that you and Tammy were the ones that made a phone call to the detention center, is that right?
Yeah.
And when was that?
The same, basically, I can't remember the exact date, but it would have been about the day after, right around the same time we would have been asked to do it. I know what you're going to, Dan. I can tell you exactly the answer to it. I was going to explain it to you before, but it's not on the phone record because it was done on my cell phone. That's
not where I was going. That's
okay. Well, I'm telling you, it's not on the phone record.
Let's not play magician with each other. Let's just let Mr. Kaczynski ask questions.
You were asked about this in an interview with Brad Tucker about Tammy, is that right? About whether Tammy would have any knowledge about this, right?
I don't remember exactly.
Can you look at State's Exhibit 6, please? I think that's Brad Tucker's interview of yours, page 8. I think this has already been admitted, Your Honor. If not, I would need permission for
No, I think it was. I think we marked this. It was marked as EE.
State. He's saying state.
Oh, it's a telephone interview of Lance Jasper taken November 29th, 23. Yeah.
I do. Okay. What page are you looking at?
Page 8.
Well,
and he's talking to you, Mr. Tucker is talking to you about this phone call that Tammy made, right, with you.
and we're talking about a lot of stuff, so.
Just take a look at it, please.
What portion are you looking at?
Page 8 at the top. If you want, you can look at page 7 beforehand to get some context.
Yeah, let's see what we're talking about.
And then so he's asking you about this, and Brad Tucker says by phone. So Tammy would have called. Does she know who she called? That's the question, right?
The question is, did we notify?
No, I'm asking you, am I reading this transcript right?
Well, there's a bunch of the questions starting on page 8. Yeah, I'm not being disrespectful. I mean, you can start, you go through about 3 pages about talking about Tammy.
And he's asking you about Tammy making the phone call to detention. And the question he asked on page 8 is by phone, so Tammy would have called. Does she know who she called? And what Brad Tucker's referencing is, does Tammy know who she called at DCCF, right?
Yeah, I see that.
And then what you say about Tammy's call, you say, I doubt it, but I can ask her, hold on, so essentially, Brad, what she can remember is that she spoke to a male, said the guy was helpful, he took down a name of our firm, the attorney on the case, phone numbers for the office, and then it just goes on, right?
Yeah.
And then Brad Tucker asked to interview Tammy, is that right?
Yes.
Is he ever able to interview Tammy?
No, absolutely not.
And what I'm looking at is State's Exhibit 9, a Newport admissions of State's Exhibit 9, Your Honor. It's an email, and I think it's stipulated too.
I don't see numbers on this. So.
My books, isn't the book right there, the whole book?
Oh,
Is that the
I
whole
didn't
thing?
realize this was yours.
Oh, yeah.
Can I have a book? Sure. See that? No objection.
Okay, so State's Exhibit 9, there's no objection, it's submitted.
Thank you. So, if you go to the, see the base stamp there, 2043?
Yes.
And that's an email from Brad Tucker to you, right?
It's in response to a previous email, yes.
And that email is dated December 28, 2023, right?
That one as well.
And what Mr. Tucker asked you on base stamp 2043 is, I would like to interview your legal assistant, Tammy Espinoza, regarding her phone calls to DCF to have the number blocked. A phone interview will be sufficient. Just let me know a date and time that works, right?
Yes.
And you would agree that Tammy has some really good information here. If Tammy's allowed to speak to Brad Tucker, she can corroborate that your phone was registered early on in this case, right?
I agree Tammy has important information, but talking to you and Brad Tucker is just not acceptable.
So I will ask you this. Nowhere did anybody ask, did the prosecution ask to talk to Tammy, right?
He is the prosecution. You are.
And then you state a couple of days later on January 2nd, 2042, I'm happy to allow you to confirm that you set up the account. However, again, there is such a conflict of interest in you investigating this matter, I cannot for the life of me understand how you are in charge of giving your role in the criminal case, right?
Absolutely.
I have confirmed with you that we followed instructions, and this goes on. Did you ever allow Tammy to be interviewed?
No.
No. And then let me ask you this question. So you were in court with Judge Rieger, I think you called it a bond hearing earlier, where we went into chambers, and in chambers you brought up the issue that your attorney-client privilege, your client's attorney-client privilege was being infringed upon, right?
Yes.
And at that time, that was in November of 2023, right?
Yeah, I brought it up there.
Yeah, and so let's start from early on. Let's talk about when Sheriff Lewis advised you that you listened to her phone call. That was in February of 2023, right?
It was.
And then when you were advised that your phone or the mail had been compromised, that was like in March of 2023, right?
It was.
So several months go by with those two things, right?
It's several months.
Yeah, and so when we get to November, when you bring it up to the judge, I'm alerted to it, right?
No, you were fully aware of it and fully aware of the fact we were trying to move him from that detention center.
Yeah, I knew you were trying to move him to Missoula, get him closer to you.
And no, fully aware that we were trying to remove him to a detention center that understood attorney-client privileges.
Well, anyways, let me ask you this. At that hearing, on the record, the state with Ms. Paddock told Judge Rieger that we would conduct a full investigation. Is that right?
You said you would do an investigation.
And we said we would report back to the court, right?
I don't remember exact words, but something to that effect.
And you had no objection at that time, right?
This was unprecedented to me.
And I'm keeping that word unprecedented. I was asking if you had an objection.
So here's the deal, both of you. I'm just saying, we're gonna take this down a notch. We're all gonna relax. We have a singular goal here, and that is to get facts on the record so that I can make a decision. So, let's rein it in. I don't want any attitude. I want each person to ask a question, and then I want them to be able to answer. You're starting to talk over each other. It's starting to be a little too snarky for my liking. So dial it back, or we're gonna be done. Okay?
Thank you, I apologize.
All right, let's go.
Did you make any objection to Judge Rieger at that time?
No to an investigation, no, I didn't.
And what you want is you wanted an independent investigator, right?
Absolutely.
And what the state did was we utilized the investigators we had, and that was DCI, to find out how their case was compromised by the violation of attorney-client privilege, right?
Say that again, I'm sorry.
We chose to utilize our DCI agents to investigate this, right?
Yeah,
And you have investigators, right?
I have investigators, yes.
And you also have the power to move the court for a motion to ask for an independent investigator to be assigned, right?
I'm not the AG, but yes, I could, I guess.
I mean, I don't know what.
Yeah, I guess I could, yeah.
And you never asked the court to ever assign a special investigator, right?
No, I didn't, I didn't.
And early on in the investigation, you actually cooperated and allowed yourself to be interviewed, correct?
Yeah, I wanted to see a good investigation.
And at some point, you start to become pretty aggressive with Agent Tucker, right? In your emails.
I try to protect him, or excuse me, I try to protect Brad at first, I do.
I guess early on you're talking about how great Brad is with Mark Strangio, who used to work with Brad, and you're singing his praises. But later on you become very aggressive with him, don't you?
I do once that I recognize that he's not going to recognize the obvious conflict of interest.
And so then at that point I send you a very short email, I ask you just to speak directly to me, not to Brad, right?
Yeah, that's when yes, absolutely.
That is on January 3rd, 2024. I write to you and I say, I'm canceling our meeting next week to discuss venue at this time. Do not intend on rescheduling. And I cancel our meeting at that time too, right?
I think there's one previous to that.
There's another email where I say that only you and I would be not to contact Brad directly anymore, right?
Yeah, that's the one where you were in control of the investigation.
I'd like to talk to you about something you said, and I'm gonna call it State's Exhibit 6 that's been introduced. And it's page 9. Can you go to page 9, please?
For the record, that is Defense Exhibit EE, just so the record is clear. You're referring to the interview of Lance Jasper by Agent Tucker.
Yes, Your Honor.
All right, I just want to make sure that,
I'll try to remember.
I know I'm going to get peeled no matter what I do, so I just want to make sure that the folks in Helena have a clear record.
So are you looking at
Which line?
Defendant's Exhibit EE, page 9, or State's Exhibit 6, page 9?
Yes, I'm looking at 2185.
Look at the bottom of that where it says, and I know. You see it all there?
Mm-hmm.
And in this, and I'd like you to review what's on page 10, the rest of that paragraph. Can you just review that to yourself, please? What you're talking about at the beginning of that sentence, it says, and I know it all ended after we had the mail issue. And you see you're referencing the mail issue, right?
I have no idea. I'm talking about mail.
And that happened in March 7th of 2023, right?
That's when that occurred, yes.
And what you're saying here is after the mail issue, you don't have any substantive conversations with your client because you believe the state law enforcement is listening to your conversations.
Objection. Calls for attorney-client.
Yeah.
I think it's already in the record. There was an email that was admitted somewhere here where Mr. Jasper says, I haven't had any substantive communications with my clients since I believe calls were being monitored. So that's already in evidence.
Okay.
So objection at this time is already in evidence.
It would be
Overruled. Mr. Jasper, go ahead and
Oh, sorry.
Let's not make this any more difficult than it
I know, but it's over.
Okay. Go ahead, Mr. Kaczynski. You may have to ask again.
Thank you.
Yeah.
And so when I'm reading this and I'm asking you if this is correct, it appears what you're telling Agent Tucker is that after the mail issue, which we just agreed happened at the beginning of March 2023, that you only talked generalities with your client and you operated as if you were being listened to, right?